Hello, everyone, and welcome to Monday. All right, just turn it up. It is 7/13/2026. Good morning, everyone. Jenna, Sheebs, Auntie M, Negla, Linza, RJ, Marcy, Maddie, Vilmarie, Jackass Karen, Becca. Who else is in here? Mr. Pike, I saw. LM, CLT, ML San Jose, Lyle Kenny, Steve. Hello, hello, hello. Dan, Cece. Hello, hello, hello. Okay. It sounds like somebody's coming in my door. Hello to everybody. Jacob! Jacob! Jacob. I love you. Hello, everyone. Okay, so we have a lot to talk about today, so we're going to get into it, but I'm also going to tell you about my weekend, okay? So I think what we're going to do, I'm trying to figure out like a format that, Cappy's here too. Hi.
Kissing face emoji.
Just don't start with me today. I've been thinking about you all weekend, fake Laura Owens. Just me and you, turning the lights down, having a burrito together, maybe cleaning up the mesita. I don't know. Thanks for that 5. Also, Princess, thank you. Was that Princess? Who also just sent me that? Somebody just sent me a 1. What happened? Or a 2. I'm so sorry. Anyways, I'm so jealous of your flawless handwriting. Thank you. People say that, and it's so funny because I think it's so sloppy. Princess Warrior, thank you for that too. Okay, listen, we have a lot to talk about, but first let me tell you about my weekend. It was a busy weekend, but most importantly, I stayed up for the fight. UFC, we're big UFC fans, and
We can eat a burrito from each end and meet in the middle.
I love it. Thank you for that 5. I stayed up to watch that fight. Now let me tell you something. My house, we used to be huge, had a 3-piece canvas of Conor McGregor in my basement. Okay? Conor McGregor has been found liable in civil court. The man is a rapist. All right? I love Max Holloway. Love him. Wanted to see him embarrass Conor. And then Conor came out and embarrassed himself. You're old, you're washed up, everybody hates you. Don't fight anymore. That's how I feel. So then I stayed up late, and then I got up early Sunday morning. And then I've been using the Blackstone. I am now a hibachi chef. What a great remake. I am now a hibachi queen. Also on my Instagram, I always wait till like things are curated. I guess I don't really know how to use Instagram. So I think I'm just going to go back to Instagram when it first came out and just like upload pictures of what I'm doing during my day. Because I don't know how to use Instagram. So that's what I'm going to do. Now, friends, we have a lot to talk about, okay? I got my handy dandy book here. This week, on the 16th, we have the meeting of creditors between Jan and Ron. Don't forget that we have Lo discussing with the judge her trial assignment at 8:45 in Arizona time on Wednesday, July 22nd. The house auction is July 28th. And then the trial assignment, because we are going to trial, is on the 29th. And I say we're going to trial because that's how I manifest things. We're doing it. It's happening. Now, today I have a lot of stuff to talk about, mostly pertaining to David Gingras and what is my fucking chat's gonna give me problems again today. I see. Okay. So this is what we're doing today. This is what we're doing today, chat. All right. Give me a second. Let me go and see if I can pull up my chat in 2 places instead of 1. I hate looking at the chat in my like live studio in YouTube because I don't want to see the numbers. I don't want to see how many people are in my chat. I don't want to pay attention to all that. I just want to pay attention to my job and my job only. But sometimes when I pull up, oh wait, I could just do that. That's perfect. Nope, still shows me my analytics. There we go. I'll look at that. Stream settings. Perfect. Itty bitty titty committee. Here, we love that. But when I pull it up so that I could do stuff like this, then, it starts to get messed up. Which reminds me, I have some random shit to post. You're old, you're washed up, everyone hates you. No one. Oh. Good morning, 2Live crew. Also, if you are in the replay crew, put your favorite emoji in the chat. If you guys are not subscribed, please consider doing so. If you haven't liked the stream already, go down to the bottom of the video, hit the thumbs up. I appreciate that. You love my son, huge UFC fan and Blackstone chef. I made an apron, James the Flame. Let's chat. I need some recipes. I need some good recipes. Didn't the foreclosure auction get delayed 2 months till the end of September, or am I dreaming that up? That is a question for Tiff. That is not a question for me, but we shall ask Tiff. How can the trial be the 29th if she's only not? I'm just giving you guys the dates as I have them. That's all. However, with that question, we are going to go through the motion today that Christian Looters wants a motion for declaration of indigency and eligibility for court-appointed experts and investigations. So we are going to, Bruder. Is 9:29. That's what I thought. Wait, no, not, okay, so now it's moved out to 9:29. Okay. All right, time out. Let me scratch it off here. House auctions off. And then we go to 9. So that's September. What do we got? September 29th, house auction. Okay. House auction. All right. So there's been a correction in my notes. Got it. Okay. There we go. We are back on track. So I wanted to read this because I think it's important that we know what's going on in real time. I have been sent this. I have not looked over it, and I thought we could look over it. Everything that people send me, I try not to read it in my private DMs because I always want to go over it in live stream. I want my reaction to be as honest as possible with you guys, and then I want you guys to see it with me as well. I know you've all probably read it, but you guys are just trying to embarrass me. Always and forever. Hello, Soko. Oh, before we start, hold on. All right, before we start, I know people are going to ask, so we'll just do it off the top. Because that's what we do. The fact that people tell me that them or their husbands or their kids or whatever are singing this song around the house is so funny to me. Because every time I hear it, I cringe a little bit. Ugh, it's so funny. Hey, Laura Owens, go to try. Hi, Amy.
We believe you.
Everybody else is a lion. Henrietta, I am not, but go ahead.
Laura,
feel like you can talk about it.
it.
We believe you. I am not. I was going to catch up on it this morning, but I was taking my criminology course. But if you want to talk about it in the chat, you can. I will listen to it before Wednesday. I promise. I promise. I promise. I legit singing it well. Oh my God. Hi, Rachel. Thank you for those flowers. They talked about vacating the July times. Okay. I think I'm back. Hi, Captain. Go to trial. Her lawyer filed a motion asking. Okay, we're going to read that right now. We're going to read that. So I see Bruce is already in his tech van today. And that's what he's doing technical stuff. Very, very hot. Very hot. Okay. Defendant Laura Owens, through her attorney, hereby respectfully, doubtful, requests that this court issue an order declaring her indigent. Which my question is, how is it that you can file Okay, so I was talking to my friend. I'm one step closer to getting her online. Not only is she a lawyer, she's in family court, she's a family attorney, but also she's a professor. So I read her this and I said, how is it that she can be considered indigent if she has a lawyer that she's paying for? And she said, well, there's got to be something funny going on there. And she said, because either he's doing it for free or they have an agreement of some sort that he's doing it until it's done and then he'll get paid so that she can file for the indigent status. She's like, that's not typically something that happens. There's something different here. Now, I don't know. I'm not a lawyer. This is just what I've been told. So it's very, very, so it's an indigency for experts. Okay. Yeah, we were going over this. We were just going over it on the docket, and I said she has a lawyer that we think she's paying for, and she's like, I don't. Um, she's like, something's different because they would have to look at her financials to be able to declare her to do that. And from my understanding, is if she can pay for a high price lawyer, then she can also pay for the experts. So I don't know. I don't know. I don't know. This is just what I've been told. Not the attorney. He may also be charging a flat fee. I see. All right. Shocked, I tell you. Shocked. I think the Owens family paid him. Now he was worried about a clawback, and it is the one thing to have your own work clawed back. But if he pays an expert out of these funds, he's really screwed. And that, okay, that makes more sense to me, right? So if the Owens family, like if Ron and Jan pay him, and they're only looking at her financials, and she's not technically paying him, then she could have God damn it, broke status, broke bitch status. Okay. But my question is it possible? Can you apply for indigency status on one thing and not on another in criminal court? That would be my question, right? Like if you're paying for this high price lawyer, but if she's not paying for him and you don't see the funds coming out of her, then that would make more sense. Because then she could file for a motion to be deemed as indigent because she's not the one paying Christian. Her parents' money isn't her money. Okay. Right. She was already declared indigent for an attorney. True. And then we were wondering, I mean, that's the big question, right? Like, who is paying for the attorney? And a lot of people, the speculation is that it's from the GoFundMe money. And a lot of people want to know who is paying for Christian. Okay, so let's get into this. Relevant factor or factual summary: the indictment includes 14 felony counts, and if convicted in trial, Ms. Owens could be facing decades in prison. We could only be so lucky. Defendant is currently unemployed and living with her parents at home. This should say defendant has always been unemployed and is living with her parents at home. New acronym, BBS. Oh, but said something about in federal court but not state court. Okay, that also makes sense. It's also different. It's household money. It's crazy how they can play this, whether she has money or not. But they only look at you. So, like, if something happened and I got kicked out of my house and I'm living with my parents and I'm 41 years old, like, they're not going to look at them. They're going to look at me. You generally cannot be represented by a private attorney while simultaneously being declared indigent for court-funded experts. So that's what I'm saying. But now I completely forgot about somebody else paying for her attorney. So if somebody else is paying for her attorney, like her parents or Sarah perhaps, or anybody else, and she's not, then she could be declared indigent, which makes sense, right? Like, Negla, if you go to court and you're broke and I come in and I pay for a private attorney, like, that doesn't work against you and indigent status, I believe. But anyways, let's keep going. Where they assist her with all their living expenses, with all her living expenses. Oof. Is this something you want to file while they're filing for bankruptcy? Because I don't believe they put on their bankruptcy that, spoiler alert. Good morning, Jack. I don't believe that they put in their bankruptcy that they're helping her with all her living expenses. Like the house and whatever, like they let her live there. But what expenses? So, prior to 2025, when charges were originally brought in the previous case, Miss Owens had a good job and a solid income. Prove it. Prove it. Prove it. Because according to what she told Jennifer Giamo, which we've all listened to out of your client's own mouth, is that she has never held a job or a W-2. She hasn't even worked for the businesses that her parents own. She was just the face. She admitted that she did zero work for them. She was just the face. She doesn't have a W-2. She doesn't have a 1099. She doesn't have a Schedule C. She doesn't have anything. When was it that she had a good job and solid income? However, she has since lost all previous sources of income and completely relies on her family for financial support. Well, that's not what they've said. I'm wondering this too, Momster, if there's going to be a notice of candor. I'd love to see it. I'd love to see it. They are filing for bankruptcy twice, Chapter 11 and Chapter 13, and never once in there have they said that they support their adult child. So I think they might be playing delaying games. Like now we have to wait for indigency investigator and then he'll need time to investigate. I mean, whatever. That's fine. In any event, Queen Jen should have all the bank statements by now. Right. Right. And that's the thing, right? The more they investigate, the deeper they get into this, the more one of two things happens. I want her to go to trial because I want to see the clownery of it all. But at the same time, I would also love to see her stand up in a court of law in front of a screen and say, I am guilty. I plead guilty. I lied. Either way, you're proving everybody right. All of her savings, assets, etc., have been expended on her multiple legal battles. Well, whose fault is that? Because of the hundreds of thousands of dollars that these men have shelled out, and perhaps the hundreds of thousands that she has shelled out for fraudulent litigation. Whose fault is that? Let's see. But he didn't say her parents. He said family. Interesting catch. Interesting catch. And that's the thing. Like, I could see, in my opinion, I could see this family going to Sarah and be like, you need to help your sister. You need to help her. Gingras said he was pro bono at one point, but she paid him in the beginning too. I don't know. Including this case. Yeah. Well, she did this. So while defendant's parents, now we have parents, provide the bulk of her support, including providing Miss Owens with a monthly allowance to cover the expenses listed in the affidavit of financial information. They themselves are currently in federal bankruptcy proceedings, which is wonderful. I'm glad you put that in there. Where did they say in those filings that they're giving her a monthly allowance? Where? While it's not listed on the affidavit, it should be noted that victim Clayton Eckerd was awarded approximately $200,000 in attorney fees and costs against Mrs. Owens or Miss Owens and the family paternity matter. Okay, that debt is still outstanding against Miss Owens. Sure. And she should pay it. Any income defendant receives and any assets she requires are subject to garnishment toward the payment of that debt, including her monthly allowance for doing nothing from her parents. Can they garnish that? Oh yeah, I guess I should just text you and be like, Big Tiff, we need you. Bulk is doing a lot of heavy lifting in that sentence, right? Was the allowance in the BK paperwork? I don't believe it was. So, I mean, what are we doing? And I love that he's like, well, and they're also in federal bankruptcy proceedings. Then you should have the access to that paperwork. Should you not? To know how much she's getting and what they said. They didn't say that she was getting anything. Ms. Owens now respectfully requests this court to declare her indigent and eligible for court-appointed assistance in the preparation of her defense. I love that. I love that. Claiming that you are actively avoiding a judgment from one of your victims is certainly a choice. We agree. We agree. Angry bee brain. I love that this is in preparation of her defense. Tells me more. She's going to trial. Somehow this family gets more and more unreasonable. I know. This will include the assistance of an expert in digital forensics. Okay. And may include additional experts such as an investigator and or mitigation expert. What does mitigation mean? Mitigation. The act of reducing the severity, intensity, or harmful effect of something negative. What? Involves presenting factors that might lessen a defendant's culpability or result in a lighter sentence. Okay, so they're going to be looking for things that help her out. The prosecution said they have terabitties from her devices. So there's that. Opposite of aggravating circumstances. Okay. The defendant admits that, as with all other indigent defendants, the specific assistance will be obtained through the Office of Court-Appointed Counsel. Now, the one thing I want to say here is, should she have a right to be declared indigent so that she's getting a proper trial? She's getting a proper and fair trial. Under any other circumstance, because I think that we should all have access to the same accommodations. You know, I wouldn't be able to afford experts if I was being criminally charged with something. However, again, she's done this time and time again. And now there's somebody paying for her private attorney, and it's like, well, she's indigent, so let's just pass the buck off on everybody else. Who is paying for that then? The state? And who's paying for the state? The people. So again, it's just more dollars being used and sucked up for this fucking disaster of a person. Turning down the severities of the charges, not denying them, which is interesting. Mental health factors are then prove it. If they want to use past trauma, mental health, whatever, fine. Prove it. Right? That would be the taxpayers. That's right. Digital expert to Laura. Girl, you in danger. I want her to get the best defense possible. Yeah, that way when she's convicted, she can't get out of it. Like now, find a neurologist to give an ASD diagnosis. Yes. So they could have her get a psych eval now, right? And get tested for those things now. But what's interesting about when you say that is she was afforded accommodations, for when she was going up against Michael Maricini and she had that disability accommodation. She claimed to have, autism then, which is why she got out of something or other. I forgot exactly what it was. But I would love to see them prove it then. Go get the paperwork. Because if you get diagnosed with autism, you will have paperwork. And the reason, right? Like myself, the reason that and that's what the doctor that diagnosed my son, he was like, keep this paperwork forever because this is going to help you get exactly what you need. Any accommodations that you need moving forward for anything. That's why they want you to have that paperwork. Hi, Minnie. The dribble doctor will find that she has any disability she chooses. Very curious about this, especially after her counsel assured the court that he was going to look at disclosure very actively and blah, blah, blah. And now it looks like she's seen the quote for that. Here, Hound Servant, the thing that pisses me off is this guy was like, we'll have an answer for you before July, whatever. We won't even need that deadline because she's already going to choose it. Although, I think what that tells me is he's like, no, you need to take the plea. And she's like, no. So I wonder if he was confident that he would get her to take the plea and she won't do it. Rule 6.4 of the Arizona Rules of Criminal Procedure sets forth the procedure of the court to determine whether a defendant is indigent. The defendant therefore requests this court issue an order declaring her indigent and eligible for court-appointed assistance in the preparation of her defense, which is a waste of fucking people's money. She's seen the money quote for his work and shit the bed. Terabytes of data is money to review in detail. No paperwork if you were diagnosed via pop-up online test. Yeah, and that's what I think, Marcy. I think he thought that he could talk some sense into her and that he could get her to take the plea deal. And then she was like, yeah, no, not me, not today. Not today. The defendant is entitled to the assistance of an investigator, experts, and the funds needed for this assistance. The paramount importance to an indigent defendant of an investigator and other services was recognized by the Ninth Circuit Court of Appeals. So we have that. Should she have access to it because she's being criminally charged? Sure. Sure. If she was anybody else, I would be like, yes, help her out. But because it's her, I'm like, oh, look it. Wasting the court's time and money. Again. And you guys are just going to keep letting her do this. Ugh. The court concluded that the failure of the state to provide such assistance when needed resulted in ineffective trial representation. In this case, the defendant is facing charges that could potentially send her to prison for many years. Oh, no. Oh, no. It's almost like consequences. Actions have consequences. Oh, no. It's almost like if you do some heinously fucked up shit, you should be punished for it. Oh, no. Ugh. Hi, Tootsie. How are you? So we're saying Cosmo magazine tests aren't legally. It's a test you take online. I don't know. Maybe hers are real because mine said I was a genius. So, yeah, right. Luxury prisons. Good Lord. To deny her the assistance of an investigator or certain expert witnesses would be tantamount to denying her right to fully investigate the crimes she faces or defenses that might be able to solely to be hello. she faces or the defenses that might be available to her solely because of her indigency. This would be clearly a denial of her right to equal protection. Okay? The equal protection clauses of Arizona and the United States Constitution guarantee the defendant the services of an investigator and other expert services at the state's expense. In Mason versus State of Arizona, an indigent federal habeas corpus petitioner challenged the refusal of the state trial court to appoint an investigator in his homicide prosecution. There can be no question that Ms. Owens, an indigent defendant, would be entitled to the resources of public defender's investigative staff if she were represented by the public defender in this matter. But she's not. But she's not. Oh, no. Oh, the diagnosis now doesn't mean she didn't have the intent or mens rea to commit the crimes against Clayton and Greg in 2021 or 2023. Also, yes. Also, yes. I don't think the state is going to let that second-degree felony go because she lied and made a mockery of the AZ judges and courts. They want her to be held accountable for that. Yeah. Honestly, part of me, now that the more this goes on, I really do think this has more to do with the system in the courts and less about Clayton and Greg, which is really sad. But according to the denial of an investigator appointed at the state's expense would amount to a denial of equal protection under the law. This constitutes an indigent ground for granting the defendant's request for declaration of indigency and eligibility for court-appointed experts and investigators. The defendant is entitled to an investigator and expert appointed services at the state's expense because a reasonable attorney would engage such services for a client having the independent financial means to pay for them. So then he has the state versus Knapp. The Arizona Supreme Court considered what type?
Only if she updates her LinkedIn to indigent.
No, thanks for that too. I appreciate you. Hi, Malin. Yeah, why don't you put that on your LinkedIn, CEO? Why don't you do that? I'd love to see it. I'd love to see it. Right, she has money for horse shows. So there's that. There's absolutely no way the Owens are going to be able to afford Luter's attorney's fees. You just don't know how much money is going to cost him and his paralegals to go through all that discovery, right? Hi, Steph. I wonder, though, if he's like, oh, I'm going to sign up for this documentary when I'm done. I would. They just want to slap low on the wrist for misusing their system. Yeah, I don't know. It's just very sad. It's very sad. And I get it. Like, she just keeps doing the same thing over and over and over again. The Arizona Supreme Court considered what type of investigative and expert assistance must be provided to indigent criminals defendants. The court noted that the issue of investigative and expert assistance to indigent defendants implicated 3 separate constitutional rights: due process, equal protection, and effective assistance of counsel, determining what services were required to satisfy the due process guarantee of fundamental fairness. So then we move down here. This is just more explanation. Because there is no question that a reasonable attorney defending a similar case would engage the services of an investigator or expert if the client had independent financial means to pay for them, Ms. Owens is entitled to the services of an investigator at the state's expense. At the state's expense. How does she have all this money to travel and ask the court? Right. She can travel. She got a new car. What else? What else? CEO and founder of Indigent Services for the state of Arizona. I am the face of the company. I don't get paid anything. If looters drops and asks a public defender, can they assign the previous PD and not lose steam so she doesn't get along extension? Oh, that's a great question. Hi, Lana. That is a great question. Can they go back? I don't know. She said she wouldn't take the plea if it included jail time. Which she won't really know what she would get because the judge, I mean, they still have to decide that on sentencing. I don't know. She said under oath that she had neither job nor income ever. Right. Playing games and stealing resources from true victims. Thank you. Thank you. Yes. Do we have any lawyers in the chat? If we do, I have a question because I think that's a really great question. Can you, if you've let go of a public defender, can you go back or do you just have to keep moving forward? How did we even find out that we have a new car? I don't know. I just know that we have that information now. So I am amazed how much she travels and gets around. I am not indigent by any means, and I can't travel at all. Like, yeah. Yeah. Good job, solid income part. She has a good job and solid income. I mean, to be fair, she is very good at what she does. Every lawyer in Arizona just took a step back while yelling, not it. Right. Right. Court should interpret statuses and rules providing for investigatory and expert services in a fashion consistent with their remedial purpose, placing indigent defendants on a footing closer to that of the prosecutors who have the resources of the government at their disposal. In this case, prosecution has utilized investigators from the Maricopa County Attorney's Office and additional expert witnesses to establish its case against Miss Owens. It would be manifestly unfair to deny the defendant the services of an investigator and other necessary experts on her behalf under these circumstances. The defendant is eligible for court-appointed assistance because she is indigent, even though her family had the resources to retain counsel. Her family. Who is it? Who is it? Yes, you can go back. Okay. So the question was, she had a public defender, then she went to looters. If he drops out, can she go back to the previous public defender so that they don't have to extend this any longer? Lindsay B says yes. Lindsay B is a lawyer, so the answer is yes. Thank you for that. If she gets to peacefully protest. We just all sit outside singing the trial song. Go to trial, go to jail. I answered that question. Oh, I'm sorry. I didn't see it. My chat, my chat, like, all of a sudden it bulks like 100 messages. It's making me very upset. I don't like it. Yeah, I guess we're trying to get justice from a justice system that doesn't ever give justice. The defendant is similarly situated to the defendant in Knapp versus Hardy, whose family was able to retain private counsel for him, but who was himself indigent. The mother in the The mother in the instant case had no illegal obligation to provide legal counsel for the defendant, and the determination of indigency must be based on his financial condition and not that of relatives and friends. Okay, well, here's the thing, right? Like, you said that she was indigent. That's fine. She could be poor now. But you also said that she used to have a job and income. I want to see it. I want to see that she lost it because she's telling everybody that she's never had that. The defendant is not asking this court for appointed counsel. The fact that her family was able to take on the burden of paying for private counsel suggests only that their efforts are saving the county the expense of providing her with a public defender. Oh, how kind. Oh, how kind. It in no way detracts from the defendant's ability to access the full range of resources that would be available to her along with other indigent defendants. This is especially true whereas here a defendant has been charged with serious offenses in which the investigation of the charges and possible defenses require an assistance of an investigator and expert, and where the denial of such services would be prejudicial to the client and the violation of her due process and equal protection rights. For the foregoing reasons, defendant hereby respectfully requests that this court issue its order declaring her indigent for eligible court-appointed assistance in the preparation of her defense. Motion denied. Motion denied. I've had enough. I've had enough. She's just sucking up time and resources. Hi, Leonicles. How are you? Didn't Clayton asked about what happens if she changes lawyers, and it was sort of answered in the last hearing. Sort of. It was in like the sentence, or not the sentencing, the settlement conference. They sort of, but also, I mean, that's the thing, right? Like, you have to allow for time. I get why they don't want to, but you have to allow for the time for her to get a new lawyer. Wouldn't a good lawyer have factored in those expenses when taking her case? I honestly think he thought she was going to take, he's like, listen, I'll get in there, because isn't that like his specialty too? Is he can get people to like, or negotiate plea deals? I think he came in and he's like, I'm going to get her to take a plea deal. And he really, truly maybe didn't understand who he was dealing with. And she had assets, none mentioned in bankruptcy. She will do everything she can to delay. I hope Queen Jennifer is aware of this contradicting motion. Laura's already getting the best legal advice. Listening to it is another matter. Yes. She will do everything she can to delay because she is incapable of thinking more than 1 month ahead. If I were Sarah, I'd change my name and move as far away as possible. I love my siblings to death. I love my siblings to death. And we don't know where this money is coming from, but I can tell you, I'm not going to put my family in a dangerous financial situation because my adult sibling is doing some dumb shit. Sometimes you just need to learn. Like, sometimes you just need to learn. Get appointed by the court himself. It would eliminate his concern about the clawback. Oh, you can do that. So, all right, let's move on to the next subject, which is talking about David Gingras. We were still on the motion to disqualify petitioners written by Omar. This was on 8/25 of 2025. I was going to skip the blog questions and comments, but then as I started reading them this morning, because I wanted to move on, but as I started reading them this morning, I'm like, so many people have so many good points. It's so interesting because it was before all of this happened, before she was it was even before the hearing with Clayton. So I just really wanted to give everybody their credit where credit is due. And I think it would be fun to continue to read through them. So this is somebody commenting, I don't know how this video can possibly be explained with the July miscarriage dates. She stated she was pregnant in the above video and appeared with a large belly. Based on information provided by the petitioner's counsel, she was not pregnant here because she had received lab test days prior indicative of very low HCG levels and had passed tissue nearly 3 months prior, also indicative of a miscarriage. It's very frustrating to see how malleable the court system can be when you have money, time, and a subscription to Adobe Acrobat. And that's another great point, right? The point is she claims that she had a miscarriage in July when she wasn't showing at all. And then she shows up in November with a belly. How is your belly continuing to grow if you had a miscarriage in July? So, usually you can get a public defender if the judge allows it, but this late, the judge might require the PD guarantees they'll be ready without extension of time. Oh, that's a good point. And just be like, yeah, go. Just do what you can. That's a great point. Would you be able to give an example specifically related to this case? Laura's had multiple medical documents now found to be doctored, as well as emails, ECT, and she claims, or et cetera, I'm sorry, and she claims all of these were modified by or created by others. So, what would her foundation be? If she didn't see someone else doing that or watch them hack and send, how can it be accepted as fact? That's a great question. And similarly, just curious, when it comes to she said, he said, how is anything accepted as truth? I just feel like on both sides there is a lot of Laura claims or Clayton claims. Does the judge just get to decide which claim is true? Moon bumps just keep growing, apparently. Janet Elizabeth and Ron pay $1,500 a month for his either term or whole life insurance. $1,500 a month is bizarre. I wonder who the beneficiaries are. Yeah, on top of that, what is it? $14,000 a month for their mortgage? Good Lord. If an individual provides a signed affidavit to the court and it's proven that the individual knowingly made false statements on said affidavit, does the person that signed the affidavit face any legal consequences? Yes. That's what we're seeing now. I mean, I think he was banking on Sarah having a Netflix documentary made and he just saw dollar signs, just my opinion. Or they paid him what he asked for because they had the GoFundMe money. That's where everyone thinks it came from. I mean, he's doing his job because he's getting paid. It's as simple as that, in my opinion. He's doing the job that he gets paid for. There is no way you can convince me that man is not getting paid. I wonder if Christian thought he could decrease the already lenient plea deal and is shocked that's not happening. The plea deal should have been for 10 years in prison so they could negotiate it for 3. I honestly, I just think, hi, Ricky. I think that he thought he could get her to take a plea deal. So I think the moon bump was full of Monster Energy with a hidden dispenser out of the belly button. Here's like bloop, 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 bloop. I love it. Let's see. You keep saying sonogram edit. However, you never explain where the sonogram came from. Also, why would you need to edit a sonogram? Friends in the chat. And honestly, this is an honest question. Under what circumstance would you have to edit a sonogram? And the only thing I can think of as a content creator is if I'm showing you my sonogram and I don't want my personal information on there, so I would redact it or take it out. But I wouldn't add new information. Under what circumstance would you have to, quote, edit a sonogram? Under what? Never. Deanna. Never as a... Number 1, to redact info. Number 2, to lie. Right. She admitted to altering it. If you say Planned Parenthood, then you are not on top of your case. So where? Planned Parenthood Mission Viejo does not provide imaging. Where is the darn answer? Where? Ugh. This is a completely reasonable question, and the answer is a both technical and a little complicated. It's Saturday evening, and we have some plans for Cinco de Mayo. So I'll have to answer this tomorrow. But I do have an answer and appreciate reasonable questions like this. This is a great question. I don't have an answer for you. Ricky, I got to tell you, that Blackstone, I love it so much. I love it so much. Or option 3, to redact info, to lie. That's right. Thank you for that, Ricky. Wouldn't it be amazing that they found her fake belly when they... Oh, God, Melinda, all of us are hoping this. All of this. We'll find out if he answers. Now, I have never seen an episode of The Bachelor, and this would have never come across my sites if your client did not take this to the press. Exactly. I am aware you call it a Clayton cult when it is a very simple question like this that hasn't been answered. Also, could Laura be found culpable for not getting prenatal care for the precious twins at any point in her 5 to 7 month pregnancy before she claimed to miscarry in January? I don't think so. I don't think so. You can't force a woman to get prenatal care. Should she? Yes. Especially when you have access to it. But I'm still waiting for the amazing evidence that he has. Oh. It is, in fact, not complicated or technical. Well, publicly, that is when she first claimed it. It is not a cult if your client has credibility issues, you yourself state. Your strong defense stands to sue the world or anyone that just reports these facts, report the facts at present. The questions this makes you look like an ass. Sometimes the way these are written, it's hard to read them. I'm sorry. This isn't about money. It should just be about truth. I'm fairly certain that is all anyone wants. Even if your client really thought she was pregnant at filing time, why show up in October for court claiming 100% pregnant with a belly? Exactly. She could have gotten out of this and just been like, I thought I was pregnant. But she had to go to the extra mile. Omar and I had a disagreement. It was in our first stream, and we disagreed because he's like, she could maybe say that she thought she was legitimately pregnant. I want to know what that's called. Think they are pregnant and not. Pseudocyesis. Or phantom false pregnancy. People with this condition believe they are pregnant and even develop physical symptoms like missed periods, nausea, weight gain, and abdominal swelling. But there is no baby. Now, you can only convince me that she had that if she didn't do the extra. If she truly thought she was pregnant, she would have gone to the doctor and been like, I'm pregnant. But she altered sonograms. She bought a moon belly. She did things to find evidence to prove her pregnancy instead of being convinced that she was pregnant. Oh, yeah. How will the 15 phone numbers show up? That's interesting. Do you think we'd get kicked out of the courtroom if a bunch of us men and women wore boom bump? Oh my God. And crop tops? Oh God. If you're altering your sonograms, then you know you're not pregnant. Exactly. You will never convince me that is like that she thought she was pregnant. I'm in shock that you don't get the public disbelief. Thank you, D-Buggy. Nobody wants this to be the case, but all signs are pointing one way. It's not a cult, it's a desire for truth. Forgiveness will go a million miles if she lied. I'm sure the court case will sum it up, but a simple sonogram shouldn't be technical and complicated. I'll wait, though. Bruce, is this you? Google Voice, I hate that. Right. Is screaming all I did was got pregnant by the fucking Bachelor a side effect of histrionic? Yeah, it is. Actually, everybody needs to scream it. I would be very interested in this comment from you. Hope it really comes today. Hi, David. So, assuming the sonogram from Planned Parenthood is real, like you mentioned above, will your expert be testifying to the presence of two fetal sacs in the photo? If not, how will you show that the provider of the ultrasound is the source who informed Laura she was pregnant with twins? Additionally, will this info be disclosed before the deadline? That's another great question. Why didn't he go back to the original person who told her that she was pregnant with twins and call her to the stand? And we're not going anywhere till we see it. Yeah, I agree. If she did believe she was pregnant, then her inability to get consistent OBGYN care for her double high risk pregnancy is extremely negligent. Exactly. Also, the fact that you had, um, the fact that you had, oh, D Buggy, thank you again. I just saw that again. Thank you. Um, the fact that you had two births or two miscarriages after 20 weeks and don't have a death certificate, right? And we have no bodies. Where are the babies? Where are the babies? That is not me. How do we know that Greg didn't manipulate space and time to do it all? How? We don't know. Check and mate. I love that. I love that through all of this, Greg Archibald Gillespie has now become Thanos. I love it. I've only been involved in 2 tweets that had DSG tagged, both of which I deleted because it became apparent he wasn't interested in the information. The way that was so logically sound. I'm like, Bruce. So are you saying, even if Laura is completely a liar, knowingly committing fraud from the beginning, she still cannot be sanctioned based upon Clayton failing to give a safe harbor notice? She was well on notice from the onset of this response that she knew or should have known her claims are false and frivolous. A lot of times, even in strict procedure, courts don't always need the magic words to rule appropriately. I have a motion on this exact issue that will be filed tomorrow. So, the answer to does he answer the questions that are both technical and a little complicated? The answer is no. YouTube doesn't like those. Why? Question mark? Exactly. Thanos wishes he was Greg. I thought I was going to get a technical and complicated answer to this reasonable question. No, you're not. You're not. Maybe. Hello. I have what I feel to be a well thought out question, so I hope you will take the time to answer. It's really just out of genuine curiosity. You have said that when it comes down to the bottom of this, really all you have to do is prove that Laura in good faith believed she was pregnant. I'm just curious if the same concept would be applied in a defamation case. You have mentioned that you could sue some of these different reporters for defamation because they are knowingly spreading lies. Similar to what you said, couldn't these reporters state that the information they shared was in good faith because of the information that they had? Meaning that they truly believed that was the truth based on the information they had. I only ask because at least information I've seen them share does have proof with it. Now, the proof might not be completely accurate, but it's what they believe to be accurate. And I believe all the information they had was accurate, to my understanding. I guess to give an unrated example to help me understand, it would be like when people get on social media or the news and say that the president has dementia. Could they be sued for defamation? There technically isn't any real medical record proof that he has dementia, but people are stating this as opinion based on the observations and things they've seen, and they do support it with their facts. I guess defamation as a whole really confuses me and seems to be something that takes away people's rights to share opinions. It's a confusing argument for me in general because oftentimes the people who are spreading information, whether it be defamatory or not, are being pretty mean. Haha. But everyone has a right to be mean, I guess. So now Gingras is not going to talk about the ultrasound. The indigent equestrian elite comment. Elite. Now he's going to talk about defamation instead of talking about the ultrasound. So there's that. Why does only Laura get plausible deniability? Great question. I'd love to know. When you find an answer to that, Seamus, you let me know. To restate the issue, you asked a question that compared the issue of sanctions, a form of legal financial punishment Clayton is requesting, with the possibility that Laura may sue some of her critics for defamation. The basic point you were trying to make, to paraphrase, why are you mansplaining her response, like her question? Aren't those two things inconsistent? Specifically, I have argued and plan to argue at trial the judge cannot punish Laura as long as she had some reason to think, oh God, as long as Laura had some reason to think that she might be pregnant. Here we go. In other words, even if Laura had made a mistake, and even if she was never pregnant, she couldn't be punished for making a good faith mistake. The fact that he could say any of this was in good faith, it's loud noises. If her claims are not false, did she murder 2 babies? Violet, where are the bodies? Where are the bodies? Your question was, in essence, whether or why that same rule shouldn't apply to people commenting about the case. Put another way, you are asking whether the law would protect people who say they think Laura faked being pregnant if it turns out that Laura wasn't faking anything. Aren't those people allowed to make good faith mistakes when commenting about the case? Just as I have argued that Laura is allowed to make a good faith mistake when claiming she was pregnant. All I want to do one time in stream is come down here and not get fucking pissed off. Don't try to logic. It makes it 10 times funnier. Right. A good faith mistake 5 times? 5 times. Hi, Stir Crazy. Right. A good faith mistake also doesn't include made up evidence. Bearing in mind, Laura has never said she wasn't pregnant. Laura has never said she wasn't pregnant. So she won't admit the case against Clayton was groundless. I think this is an excellent question, among other things, because you are right. It probably does look a bit inconsistent for me to say that Laura is allowed to make mistakes, but her critics are not. I will do my very best to explain my views on this, keeping in mind that these legal topics are very complicated, and it would probably take 100 pages of briefing to explain every aspect of this area of law. Hi, so well hidden. I love that he's like, listen, this is probably way too complicated for you to understand with your small lady brain, but let me mansplain it for you. Let me mansplain it. Let me do this for you. By claiming she's pregnant when she wasn't and didn't take them to court. Right. Good Lord. Here's the best response I can give you in a reasonably short format. How long does this go on for? Jesus, God almighty. Oh my God. TLDR, I'm going to talk in circles so you forget what you asked. Exactly. By the time she filed the paternity and parenting plan with the court, she had not attended any OB/GYN appointments and had already sent Clayton the altered sonogram. There was no good faith. Thank you. And look at the timing. That's right. I get angry and dysregulated, don't we all? Sort of. What does that mean in Latin legal terms? All right, here we go. This is the short format, friends. Get a pillow and a blanket. Make yourselves comfortable. First, you are correct. Sort of. But the rules of court sanctions and the rules for defamation are very different, largely because damages caused by bad legal proceedings are normally a lot smaller than the harm caused by publishing false statements that harm a person's reputation. I mean, in this case, she filed a legal proceeding to go after his reputation. So there's that. Harm from bogus legal proceedings are usually minor, while harm to a person's reputation can be life-changing and often nearly impossible to repair, which is what she tried to do to Clayton by taking away his business opportunities. When it comes to punishing people for filing bogus court cases, as Clayton is trying to do to Laura, I'm sorry, what? When it comes to punishing people for filing bogus court cases, as Clayton is trying to do to Laura. I miscarried with my last sweet baby girl. Oh, Everly Rose at 18 weeks. She would have no doubt it was a miscarriage, especially if it were twins. Yeah. I'm so sorry, Hollywood. I'm so sorry. So I have a client that I talk to all the time who's a nurse. And hi Alfire. I have a client who's a nurse, and I've talked to her about being on the show as like a consultant expert for things like this. And she's like, yeah, I'd love to. And we were talking about mifepristone and misoprostol and that how it works and what people experience and what they go through and things like that. And we were just talking about there's no doubt in anyone's mind. I mean, unless you're miscarrying at week 6, week 7, week 8, you typically know what's happening. When it comes to punishing people for filing bogus court cases, as Clayton is trying to do with Laura, the law is very clear. People are allowed to make mistakes. This actually happens all the time. Sometimes the mistake is accidental, and sometimes it's intentional. You know, guys, can anyone in the chat explain to me how a mistake is intentional? Is this like I break dishes so that people never ask me to wash them again? Because then it's not a mistake, it's on purpose. If something is intentional, hold on. If something is intentional, can it be a mistake? An intentional action can still be considered a mistake if the intended action was carried out correctly, but led to an unplanned or undesirable outcome due to poor judgment, ignorance, or flawed assumptions. I mean, hi, tax packet. Hi. He admits that Laura's case was bogus, and his complaint is that Clayton didn't let her get away with it. I think always is what his. I used my printer to copy $100 bill I got like 1,000,000 times. Does that mean I have good faith to believe I'm a millionaire? Oh, God. But wrong context. Ugh. If cheating was a choice and not a mistake, attempting to blackmail 5 men into dating Laura would be a choice. He's giving away his playbook. Ugh. I hope you stretched before you started the rapid head turns, and don't forget to ice down when you're done. But either way. But basically here, I love this definition. An intentional action can still be considered a mistake if the intended action was carried out correctly, She did what she wanted to do, but it led to an undesirable outcome due to poor judgment, ignorance, or flawed assumptions. She thought she was going to get her way. Whoops. Fucked up. But either way, the standard for what that person needs to do in order to bring a court case against someone is very, very low. If you sue someone, all you need is some basis to think your claims are valid. 100% certainty is never, ever required. So as long as Laura believed she might be pregnant, the court cannot sanction her. That's just the way the rules work. Okay, but if she thought she was pregnant, why did she alter sonograms? If she filed the first affidavit thinking she was pregnant, but then still kept going, that's not an accident. It's not one time. It's not she filed the affidavit. She kept trying to file motions, and Clayton had to get an attorney. Ugh. It's not a lie if you believe it. What was my husband singing the other day? Believe it or not, George isn't at home. So leave a message at the beep. If you are pregnant, you do not have to steal someone else's sonogram. Right. Right. I mean, and that's the thing that bothers me so much about Gingras is this concept is not hard to understand. In paternity cases like this, a woman is allowed to bring a case simply because she hooked up with a guy and she just felt pregnant. Okay, and that's fine. If it was one affidavit and then she let it go. But it was time after time after time after motion after motion after money, it kept going. There is no requirement that she have any sort of test first. There is no requirement that her pregnancy be confirmed or validated. A one-night stand and a single missed period is all you need. Laura had that. A one-night stand that was oral sex and a missed period that she doesn't get because she claims she never gets periods. So that's a feeling thing now. Actually, Hound Servant, I feel pregnant right now. So I feel it. I feel it. It could be the fact that I had 2 hamburgers and enchiladas yesterday, but I mean, I feel pregnant. I feel it's moving, it's kicking. Laura had that plus 5 pregnancy tests, including one given to her by Clayton, which she took directly in front of him. It was HCG. It was not a pregnancy test. There was no proof of life in her belly. There was no ultrasound. There was just HCG, which we now know that you can just take. The way you read this in all shop. Thank you. I had a miscarriage when I was 18. I didn't even know I was pregnant and I thought I was dying. When you miscarry, you know something's going on. I had to do a DNC so I wouldn't go septic. Oh, Josie, I'm very sorry. I'm very sorry. And that's the thing. I mean, that's why everybody gets so upset, right? Because she keeps telling these stupid ass stories. And the fact that Gingras just doubles down. Why? What benefit do you have to double down on this? But let's ignore those facts. Okay? I mean, it seems you do. What if Laura knowingly lied? Can she be punished then? The answer is kind of surprising. Maybe yes and maybe no.
I feel pregnant when it hits my console.
Ew. Ew. Thank you for that 5, Laura. Ew. Ugh. Ugh. Yuck. Here's why. Because of the way our rules of procedure are set up, people are allowed to file cases they know are 100% false or fraudulent. No, they're not. No, they're not. Which is why she's in the issue that she's in. I mean, I know it's shocking, but Bacon bears with me. People are allowed to lie in their papers. They can even commit perjury in certain situations. I know this because I've personally seen it happen in other cases. People can get away with murder. That doesn't mean they're allowed to do it. Just because they do it and they don't get caught and you've seen it doesn't mean they're allowed to do it. Can they commit perjury? Sure. Are you supposed to? No. He said, what? Are they getting set up for an appeal, kicking the can, or both? I think she is trying to go to trial, honestly. Right. To be fair, you can lie, but there are consequences. As my human right, I can walk up to somebody and punch them in the face. I can just do that. Am I supposed to? Not really. Could I get in trouble? Maybe. Does it make it okay? No. It's even happened to me. As I explained in my prior post about the time when I was sued for paternity. You fucking idiot. Here we go, apples to oranges. For those of you who don't know, David Gingras was sued for paternity, and there was a real live baby where they did the test, and then they threw it out because he knew, or they knew through DNA, that...
Bacon Tourette slows new defense. I say I'm pregnant with twins when my Tourette's kick in.
Oh my God. Thank you for the 10, Seamus.
Go to trial, musical notes emoji.
Oh, thank you for the 2, D-Buggy. Hi, Charlie. I'm the real Bacon Bears. Prove I'm not. Oops, I just lied. Weird how that works. Right. You have the ability. What you lack is the capacity. Ugh. 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 Today's gonna piss me off. Okay. Gingras had a real live baby that this lady was like, Gingras is the daddy. And then he's like, no, I'm not. And then they got a paternity test and it turned out that he wasn't the dad. Ta-da! See how that works? Do you see how that works? When a real life baby enters the chat? Great point, Danny. Great point. Yes, we have rules that say a court can punish someone who lies in their pleadings. But there's pretty strict process that must be followed before any punishment can happen. The idea that if a person makes a mistake and lies in court, the law wants to give them a way of admitting fault and fixing the problem without facing life-altering consequences. If a person makes a mistake and lies in court, no. Lying in court is perjury. All right. I don't know if Gingras, I don't know if he ever has been in court, but you walk up and a little lady or man is like, hey, are you going to tell the truth, the whole truth, and nothing but the truth? In a court of law? Under penalty of perjury? You promise not to lie? You promise to just say what happened? And you're like, I do. And then you go up and you sit down and you tell the truth to the best of your ability. So help you God, thank you. So help you God, right? And then you sit down and you tell the truth to the best of your ability. You may a mistake. I may say I got in this blue car with stir crazy. It's really a brown car, shit like that. When you maliciously lie, the law does not want to give you a way of admitting fault and fixing that problem without facing life-altering consequences. That's why when you walk up to the stand and they hold out the Bible and they tell you to raise your hand and they're like, hey, don't fucking lie or you're going to be in big trouble. They do it before you even sit down. That's like the whole thing of testifying. Making a mistake. I'm actually pregnant, thought you might be the father. Turns out the other guy is. Right. If you drink French wine and bite your toenails, would you say you have a French pedicure? The fuck? You're startling. Oh, I'm sorry. You can say something, but then say I made a mistake and adjust your statement is allowed. You must do it before the other side corrects you. I have seen this so many times in district court. Thank you. Thank you. Good Lord. So the rules basically say if a person lies in their case, you have to give them a written warning first, and you have to give them the opportunity to fix their mistake by withdrawing their claims. Right. Tell me, when did she withdraw her claims? Did I miss a chapter? Did I skip a chapter? If you want to punish someone for bringing a fake fraudulent case, you must do both of those things first. If you don't, the law literally says the bad guy cannot be punished, period. Deandra, well, this is before Deandra, right? Because this is before the hearing. But Deandra literally says to her on the stand, I am giving you the opportunity right now without punishment to admit that you're a liar, girl. And Laura was like, I have never lied. Okay. Okay. So there's that. And I don't know. I don't know. Ugh. Was for the IHAs, not the paternity. No, it was a paternity. No, she stood in front of her when Laura was on the stand. And she said, the very last thing that she said to Laura was, I am giving you one last opportunity to correct the record and say that you were never pregnant. And Laura was like, absolutely not. And in this case, it is undisputed Clayton's lawyer never gave Laura the correct type of warning. The rules are very specific and they must be followed exactly. But Clayton's lawyer didn't follow the rules. He has basically admitted this. This means Clayton cannot get sanctions against Laura, even if she lied, which she absolutely denies. So I made a mistake, but cost no one money. Interesting how simple that was. Right. Right. Clayton's lawyer never gave Laura the correct type of warning. Now, let me address your question about defamation. If Laura is allowed to bring a court case that turns out to be groundless, either because she made a good faith mistake or because she knowingly lied, but Clayton's lawyer failed to follow the necessary steps to get sanctions, should the same kind of loose standards apply to people who talk about this case? If a person said they believe Laura lied and it turns out we win the case by proving she did not lie, shouldn't that person still be prosecuted or protected against getting sued for defamation? Oy. There's just so much back and forth that doesn't need to be happening here. It's too much back and forth. The answer is also, okay, I see my numbers are at almost 6,000 here for views. So thank you for the 2.
6,000 viewers, you go girl, thumbs up emoji, thumbs up emoji, thumbs up emoji.
So I did a little research and I want to tell you guys because people were talking about buying viewers and I was like, never on my life. Here's what I'll tell you. I found a couple of things. I did some research. And I guess when your channel is doing well, YouTube will try to put it out to the algorithm to bigger audiences. But also, if people embed your videos on other websites, they have access to watching your videos, but not access to the chat, I guess. And when I looked at my analytics, it was saying that it was being broadcast like somewhere else on like a blog spot or something. So I guess there's that as well. So let me just say for the people who are watching this live, my name is Bacon Bears. I have a YouTube channel on YouTube called That's My Opinion, where we cover legal accountability, just accountability in general and true crime. If you guys want, please come over, subscribe, please come into our live chat. We have a really great community. We have a really great time. We are all wonderful. We have doctors in here, we have lawyers, we have social workers, we have IT people, we have so many people who are just so wonderfully intelligent and just want to have the best time and have just like critical thinking discussions. So that's what we do here. I would love to see you. I would love to have you. So if you are on a different platform or you are on a different website, please come over. And until then, enjoy the rest of the content. I forwarded your channel on Facebook and X accounts. I have a fairly good following on X. Oh shit. Oh shit. Maybe that's it. I don't know. Maybe it is on Facebook. I don't know. I don't know, whatever. But it could be on something else. The answer is most likely everything in law. Maybe it depends. Defamation is a very complicated area of law. But the main thing to know is that, yes, the First Amendment does give you very strong protection against getting sued. That's interesting because Gingras liked to talk about how people couldn't have their opinions and they couldn't say what they wanted to say because he was going to sue them for defamation. I remember that, right? Right? If I lie about lying, then 2 lies cancel each other out. Math! Math! Thank you, Charlie. I appreciate you. People in UK have come from work and have had their tea. They're just tuned in. Hey! Thanks, Duchess. I love that I have people in the UK. I have people in Scotland. I have people in Sweden. I have people in Australia. It's so fun. I love this. If you say something that is completely true, it is almost impossible to get sued, but again, there are exceptions to this. Generally speaking, there are 2 main types of defamation cases. 1, private figure defamation, and 2, public figure defamation. If you publish something false about a private figure, someone who is not a celebrity or politician, the plaintiff usually has to show that you acted negligently. That means you failed to do something that a reasonable person would have done. This is a very low standard, and it basically means if you publish something false about a private person, you will probably end up losing unless you can prove that you did act reasonably. Again, super complicated, but relying on something you read on a blog or social media might be reasonable in some cases, but not reasonable in others. That's basically a decision the jury would have to make. Now, you know what I would have loved to see him like go over here? I would have loved to see him address the Sun article that she brought to light. Bankruptcy video. What is it? Blah, 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 blah. Oh my God. I know our legal system is insane. It's insane. But But okay, did she or did she not bring forth a publication or an article to the Sun to try to defame Clayton? Did she or did she not go to Clayton's employers so that he would lose his speaking engagements? Yes or no? Considering how it went. I know, I love that we get to see in the future with this. It's pretty awesome, actually. Now, the plaintiff is a public figure, usually a celebrity or a politician, or if the speech involves a matter of public concern, the rules are different. Now, in those cases, the plaintiff will have to prove that the defendant has something called actual malice. That term has special legal meaning that is probably different from what you think. Did she, when she went to his employers and when she went to the Sun, not have actual malice? Please. Please. Actual malice means the defendant either knew his or her statements were false or they acted with reckless disregard for the truth. Sounds like somebody I know. Reckless disregard is something higher or worse than simple negligence. Reckless disregard typically means the defendant intentionally ignored information that would have proven their statements were false, basically sticking your head in the sand and refusing to look at evidence that supported the plaintiff. It's almost like Laura stuck her head in the sand. It's almost like you're sticking your head in the sand. I'm still waiting for my 120 million. Don't you think I forgot? Don't you think I forgot? Michael Morton Act. What's the Michael Morton Act? Michael Morton Act. Michael Morton Act is a landmark Texas criminal justice law signed in 2013 that reforms the open file discovery process. It requires prosecutors to automatically disclose all evidence, police reports. Yeah, okay. What does that have to do with anything? That is the same concept. Huh? We're talking about defamation. Charlie, what are you talking about? I'm going to need you to explain this further. He who smelt it dealt it. I love how how wildly immature it gets. She was trying to takesies backsies, which is not the same. Also, yes. Based on these standards, I think it is fair to say that for most people commenting on this case, they don't have to worry about getting sued for defamation. You absolutely are allowed to have an opinion. Opinions are never grounds for a defamation case. You can even say you think one party is right and the other is wrong. What you cannot do is make factual statements such as Laura lied about being pregnant. Well, I can now because that's what the court deems. The court deems that she was never pregnant. The court deems that she brought a fraudulent case to the court. So now I can say that shit from the time the sun goes up till the time the sun goes down. Exactly, Kimbo. My legal response? Nuh-uh. 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 Or Laura did this to other men in the past. Then prove it's false. Those are not the statements of opinion. Those are statements of fact and that can support a defamation claim if Laura proves she didn't fake being pregnant and if the speaker has the correct mental state, either negligence or actual malice, depending on what a future judge thinks should apply here. The bottom line is that when it comes to free speech, people typically can make a good faith mistake and not risk liability for defamation. But people who spread false statements of fact because they want to earn money from advertising revenue are not engaging in protected speech. They are commenting or they are committing intentional defamation, and it's seriously no joke. These attacks have been devastating to Laura, which is why I'm confident that if we win the trial in June, oh boy. Narrator, they didn't win. Many of her detractors are going to have a lot to answer for. Nuh-uh, sustained. She can feel pregnant, and we can feel she's a liar. Oh boy. Yeah, what the hell does the court know anyways? What do they know? When I was at school, I had this mad history teacher who had taught at the kind of schools the Windsors go to. He used to scribble over bad writing with a big red pen. I am picturing that on this toot. Oh my God. Grounds. His biggest problem is that when he said somebody lies, he never proves they lie. He just asserts it. I don't, right. Ah, good Lord. What is happening? Just to clarify, at some point, Laura knew she was lying about being pregnant currently, or at least knew she was no longer pregnant. But because nobody told her, an adult, that she had to admit this, she can't be held responsible. That's a great question. It says at the bottom of the paper, right? Under the penalty of perjury. Obviously, she can read. She was able to fill out all of those questions. So did she just miss that part? I mean, I don't need another adult to tell me that I cannot lie in court. Dave, there are two questions I've not seen addressed in your filings or your posts. When did Laura learn she was having twins? Is she claiming the October sonogram is fake? Hi, loud little ducky. Laura says she was told by Planned Parenthood that she was pregnant with twins. When? When? Not who. When? This was the ultrasound that she later admitted to editing to change the name of the facility. No. Not just the facility. Also, her name on the sonogram. I don't know what you mean about the October sonogram. To my knowledge, there is no October sonogram. It's possible you're talking about one or more fake sonograms that someone else. Oh my God. Thank you, Steph. Frequently wrong and extremely defensive. Apart from that, he's got it all going on. It's possible you're talking about one or more fake sonograms that someone else has created. Like your client in more than one scenario? When, not, who. I know. And then sent to certain online media people. Like Laura, who took her pregnancy stuff and sent it to Dave Neal. All hail Dave Neal mention. It was before my time. Laura's denied having anything to do with those, and so far I haven't seen any evidence to the contrary. Well, good news. In about 1 month, she's going to tell everybody in that courtroom and who's watching that stream that she did, in fact, alter her sonogram. So, this aged like milk outside on a 90-degree day. Oh my God. Oh my God. Have you seen the original ultrasound? Who told her it was a boy and a girl? Then what video ultrasound did she testify about? And why didn't your expert rely on that? Thank you for your info. You make it easy to find proof against her claims. So for real now, are you defending Laura or Clayton? No, this is before the June 10th hearing. So that's why I said, because this is before the hearing. In the hearing, she does admit to altering the sonogram. Yeah, gosh, I seem to have a copy of the email where she sent her father rubbing a pregnant stomach video to Clayton and Steve, a guy named Reality Steve, and Dave Neal, both content creators, both commentary creators. Good Lord. Are you the daddy next? Will you be representing Laura Owens if the owner of the sonogram decides to sue her for falsely claiming that the vanishing twin sonogram was hers? That isn't a valid legal claim, so I don't expect anyone will sue her over it. So you're admitting that she's falsely claiming that the vanishing twins sonogram was hers. Hello? Sun milk is not blue cheese. Interesting that he modified that with so far, as in, I know she's probably lying, but I have no proof as of yet. Ugh. Computer and internet fraud, the act of defrauding, could include altering or deleting records, accessing financial or other information, or obtaining something of value. Isn't a legal, valid claim. Laura stole a medical record for her benefit. Several valid lawsuits are available through the Health Insurance Portability and Accountability Act. Okay, that makes perfect sense now. Do you know who planted the ultrasound in Laura's public Dropbox? Which I still haven't seen yet. I still got to get there. Oh my God. Hi, Sarah. I didn't see you floating around in that chat. Then hacked into her email to send the email containing the fake ultrasounds to various online personalities with the exact same email trackers that she uses. Have you filed charges against that suspect? Seems like it could be considered stolen identity. So you haven't seen the email Laura sent to a podcaster, Dave Neal, linking that same ultrasound. Strange, because that was in the filing. Hard to know what you're referring to, but my understanding is that someone sent an email pretending to be Laura that said, here is my 100,000% real ultrasound, and Laura has always maintained that email was fake. You know what is not fake? My name. It's Bacon Bears. And I maintain that. It's just Bacon Bears. It's not fake. Dave, the call is coming from inside the casita. Hi, Swamp Witch. How are you? Oh, my goodness. Yeah, I know. I wonder where it's being broadcast at. Also, if you guys are broadcasting me and making fun of me, cool. Whatever. Thanks for the views. Let's see. But other emails in that thread were real. Great. Oh my God. Yes. Great point. So what about the other ones? They just inserted that one, but not the other ones? What will happen if it's found that it was sent from her, just like the forensic team found the texts were sent from Laura to MM? Still waiting for that explanation on the Planned Parenthood, but not Planned Parenthood ultrasound. We're all still waiting. I think the 7,800 new viewers need to hear the Laura Owens song. Also still waiting for an answer on when she was told she was having boy-girl twins, by which provider. I feel like these are reasonable questions. Trial song for new viewers. If you guys are new here.
Because that's what we do. We Tell Laura.
My name is Bacon Bears.
To go to trial, Laura Owens.
We have fun.
Do it.
Yeah.
We believe you.
We like justice.
Tell your story.
Too much.
Go to trial.
Yeah.
You're not a liar. We believe you.
Hey.
Do it.
Hey, Laura Owens.
Go
to trial.
We believe you.
Oh, hello. All right. How about now? Can you hear me now? Hello. I'm just going to play some music and see if you can hear me. Anybody? Hello. Do we hear porn music? Good Lord. Hello? Okay. She go, wow, wow. Question mark! All right, listen, friends. You owe us one single replay. All right, here we go. I don't know what I did. I just, so I unplugged my Rodecaster and put it back in. Because with these numbers, I'll be damned if I'm going to turn this damn stream off. So, with that being said, I will give you a redo. And then I won't touch a goddamn thing, okay?
Because that's what we do. We
Tell Laura to go
to trial Laura Owens. Do it, do it.
Yeah!
We believe you. Tell your story.
Hey!
Go to trial.
Did you just say about to
You're
get stuck in
not
the
a
dryer?
liar.
Elja, God!
We believe you.
Oh no, my
Do
stepdad's
it,
home.
Do it.
Hey, Laura Owens, go to trial.
We believe you. Everybody else is lying. Go to trial. Get your jumpsuit in jail. We
In jail.
believe you.
All right, there you go. All right. For anybody who's new here and watching, please go down and like the thumbs up the stream. Do that. The schmexy music was on. It's going to be ringing through the house. Sorry, everyone. All right. Hi, David. Why no answer for the Planned Parenthood denying the...
That sounded like the beginning of Tony Robbins' night, kissing face emoji.
Bet. I got a mug just for you, Laura. TR&B hole. TR&B hole. Oh my God. What is today? It's July 13th. It's a Monday. Is it a full moon? When's the next full moon? Poor Tiff. Tiff is texting me. We can't hear you, LOL. Do you have a mute button on the side of your mic? I've done that before. Woo! Tiff, you're my favorite person. Why no answer for the Planned Parenthood denying where the ultrasound came from? Thought they were getting one today. You and me both. Lord knows what the potential answer could be. Someone physically placed a sonogram in her hand. Who was it? And where was it at? Also, I love that this chat has also said that or also hinges. Words are hard. Okay? Words are hard. I love that you guys now know that Gregory's fake middle name is Archibald. Thank you for the jewels. Words. I thought I was your favorite person. You are. You're all my favorite people. Next full moon will be July 29th. Okay, we can all do our witchcraft then. You're sending it all to me. This should be the easiest thing in the world. Should be. Well, it appears Laura's trying to possibly settle. That might be why we can't get this basic question answered. However, if a full confession is provided, unconditional forgiveness should follow. Thank you, Michelle, for those jewels. Appreciate you. Everyone has only asked for this gal to get help. I'll be the first to say we are praying for self-help only in the truth. However, maybe this is not the deal and it's a smokescreen. Who knows? This is a completely reasonable question, and the answer is both technical and a little complicated. So technical and so complicated that it clearly doesn't exist. Yes, let's go. Thank you, Tommy. Take a deep breath. Oh my God. I didn't even think about that. I named him Greg Archibald Gillespie. So his initials would be GAG. I love that so much. Crystals and candles, let's go. I'm your work wife. I love that. Thank you for the jewels, Miss Bell. That's so funny. Oh my God. What would you do if the metadata for 21-week sonogram and 2016 ovarian cancer messages came back as linked to Laura, aka she lied yet on affidavit? Would you drop or continue to represent her? He won't answer because he can't. The only answer is that she lied. Hi, David. I've been patiently waiting for the truth to come out, all the way back from when Laura went public. She posted to Reddit, left links in her Dropbox, patient portals, and then went to the tabloids, etc. I was 100% on her side. But David, put my mind at ease and tell me I'm mistaken. In Laura's PPO trial against Clayton, she told the judge that the sonogram was 100% real and that Clayton was the only other person in the world that had access to that. Also, the picture of showing her stomach, she told the judge that she and Clayton had those pictures, and the only explanation for them being online was that Clayton leaked them. As it should, it now only swayed the judge, but quite rightly given those facts, it angered him, which he repeated in his order granting the new PPO. Now, forget all the other cult stuff. I know for a fact
$10 and some change. Praise the bacon. And yes, that's her real name. Wink wink.
Thank you, Bishan. 7.8. I know. I don't know what's going on. I can only think of a couple things. My stream has been embedded somewhere where people are watching, or it's being distributed off of that thing, which can count as views towards YouTube, I guess. Or somebody is fucking punking me. And since we talked about buying followers, somebody bought followers, which what a waste of your money. For my channel. I hope it's Laura, you guys. What if Laura bought followers or viewers? But anyways, I don't know. It's all very confusing. But when I asked, I'm like, would viewers, like if it was bots, would it go down? And they were like, yeah. If you're not in YouTube and you're a viewer somewhere else, tell me where you're coming from, because I would like to know where my stuff is being put out during the criminal trial, right? We are proud of you. If it's real, we're proud. Hi, Wallace. Yeah, and also if someone is buying views, please don't, because it doesn't, I mean, it sort of helps me, but not in the way that I would want it to help me. But anyways, whatever. Now, forget all the other cult stuff. I know for a fact, because I was supporting Laura, that those pictures were available to anyone on Reddit, and I can't get my head around why she lied. The truth is the truth. As of then, she didn't need to lie, so I'm asking if you have spoken to her at least about that. Thank you for your updates and transparency. Take care. Not only swayed the judge, but quite rightly given those facts, it angered him, which he reiterated. Oh, apologies, typo in grammar. Okay. Please read what Paul just said. Most of us were on Laura's side when it all started. She was responsible for telling us this horrible story that was happening to her. Clayton was one of the most hated bachelors. To have the public change and support him tells a lot on itself. Even if you really believe every other thing she said was true, I see no way to explain why she lied or would lie to a judge in court. She claimed the picture she was holding was of their son. She sent it to Clayton and the media. Why wasn't it in her medical records? If you do the honest thing and drop her, I hope you encourage her family to get her help. Someone who sues every man who denies them is leading a very sad life. I'm extremely worried for her and disappointed her family is too afraid to help. If you want the exact date and timestamp of the court video, I would be happy to send it to you. Nicole, thank you. Take a look at the pictures. She is holding the horrible Halloween costume. That's the one. And it seems by it seems that everybody, I mean, most of the people who are writing here seem to be pretty compassionate, right? Like they seem to be pretty, what's the word, like they just want to see her get help. They don't want to see her go down in flames. They don't want to see her, now after all of this, it's very different. They definitely want to see some justice happen. But, I people are very understanding on this blog. All right, what did I miss in the chat? Thank you for that 10, Bishan. Bishan. Usually watch on. Hi, Sean Barry. How are you? Charlie, thank you. UK Derby says hello, hello. Hello from Mars. We need all those people to hit the like button. Let's see. They're right. They're being incredibly fair. I agree with that.
I'm watching via your OFans page.
My O fans. Well, I mean, you're getting a lot less over here. If I was on O fans, you'd be getting a lot more. So there's that. But thank you for that too. I appreciate you. DSG probably deleted any unhinged comments from his blog, which is reasonable. Someone's gotten awfully quiet in the past few days. Seems very out of character for you. David, hopefully you're taking the time to decide if this is truly the hill you want your reputation to die on. Representing Laura and very publicly doubling down, supporting her blatant lives will give you notoriety and attention, to be sure. Thank you, Karen. It is not the kind you should want. No one is laughing with you. Laura's doing bad things for herself, for you, or these men, for women at large. I mean, she certifiably lied about having cancer. She's not a good person. She's not worth throwing away your reputation for. She is not worth lying for. She needs help, and she needs you to drop her as a client. This has gone too far. Yeah, I feel like we have all been fair during this whole duration. We simply wanted the truth and then further down justice. Yeah, I lost all my understanding when she tried to blame this all on her fake autism diagnosis. Yep. Yep. Big antlers, 24/7 on his only antlers. Let's go, Bruce. Show him if you got him. For the record, I don't think you should drop her as a client, especially if you can help her. I think Lexi stumbled across something maybe you didn't yet, or it was privy to a conversation you hadn't had. But she obviously needs to be represented. The question for me is, to what end? If no middle ground can be reached, like my previous question to solicited, then what are the realistic next steps? In my opinion, I don't think this is really about money. I think Clayton wants a judgment or the ability to say, I told you I did nothing wrong. Yeah. Yeah, I don't think it's about money. But also, subscribed. I also think that, yeah, he wanted an opportunity to clear his name. But also, why shouldn't he get paid back the money that he was making? Also, let me finish this thought and then I'll go into the other things. All right. It's obviously my stuff. It's obvious my stuff is being streamed from somewhere else, because that's two people who have now given money that don't usually give money. So obviously somebody's watching. Thank you. So there's that. But also Clayton, yeah, she should be able to clear his name. But why shouldn't she be responsible for paying his legal fees when she brought a fraudulent case against him? Why should she not be responsible for that? And I think Laura probably wants the same. So if you apply some logic, weigh the numbers like you do, is there not a compromise there? Example, Laura says, I really thought I was pregnant. This is spelled taught though. But the evidence seems to suggest that maybe I wasn't. When I thought I could and should have handled it better. For that, I apologize and I'm willing to do some reflection. And if necessary, some treatment. I apologize to Judge XYZ and Clayton. And also too, be careful. Money isn't from a scammer. I mean, it goes through YouTube chat, so it's not like they can get it back. But the other thing is too, I would have understood if she came out at the end and was like, I got myself too far deep. I didn't know how to take it back. I didn't know how to get out of this. Like, I was too scared to get out. I was too afraid to admit the truth. Like, I just didn't know how to do that. And she still wouldn't do that. She still doesn't do that. She still comes out of Medium blogs. And she still, does things that she talks about how she's not guilty. They may try to reach outside of YouTube. Well, yeah, no. Clayton says, I crossed the line without you the night we met. It was very unprofessional, and the way I treated you in the following days was wrong. My videos were unclassy. and I definitely could have done better. We are both still very young and should move on from this. We both drop protection orders. We don't seek fees. We both either not obtain the right to speak publicly on this matter without fear of any lawsuits. The agreement can be sealed for 10 years or whatever, and everyone moves on. If other stipulations are required in private and are agreed to speak on publicly, then so be it. If I was weighing this, despite the egos involved, I would be saying it's either this or spin the dice at trial, which she did. It could be a lot worse. Everyone gets a little of what they want from weighing. I'd say 4 out of 7, Clayton, 3 out of 7. Oh, wait, 4 out of 7, Clayton, 3 out of 7, Laura. Is that even in the realm of possibility, David? Again, thank you for your input and time and willingness to engage. God bless.
Question mark?
My God. Hi, Miss Me. How are you? Welcome. All right, let's see. And compare them to hers to prove she's... Oh, well, you don't need to do all that, but we know she's lying. I feel like then she would pull a Sherry Papini. Right. They made me do it. They made me say. David, better make sure you get your malpractice insurance in order. Your client will certainly be attempting to sue you and report you, as she has done with many of her lawyers in the past. If it were me, I'd drop her and move on. David, and that's the thing that I've said for a while. I do find it very interesting that he would go this route, not knowing her. She was just a random client. Like it does not make a lot of sense. How about you take this? Oh, I'm sorry. David, why are you responding to some questions but none about the Planned Parenthood, denying where the ultrasound came from? You said you'd address that days ago. How about you take this down now because you promised to take down anything that Mike wants you to? He has not asked, so. Just because someone has not asked you to take something down does not mean that you should not do it. Why have you continued to ignore the PP ultrasound questions? They deny ever even seeing her or doing any ultrasound. Seems like her arts and crafts are unraveling. Very lame excuse. No reasonable person would read that message from Mike to you and think he doesn't want this blog taken down. The guy hasn't asked. Why is this what you're focusing on? Like, why? These are the only comments that you're reading? Your obsession with technicalities and thinking you are smarter than everyone else by picking and choosing how things can be construed is childish and comical. You're obsessed with your own brain and thinking you know better than everyone else. If you claim to be so intelligent, you would reasonably infer that if someone asked to be removed from Twitter, they want it removed from your blog as well. But technically, he didn't ask. I love when people spell shit like this. It makes me laugh. You are a complete joke of an attorney. Take this down. Both you and your client are letting your mouth write checks that your butts can't cash. You're both about to get yours, and we will all be enjoying watching her get hers and what she deserves. David, I just want to reiterate that I fully supported Laura 100%, no questions asked. Why only that, right? It's only these. Well, maybe we are all just new to your channel and loving it. I've only recently just subscribed and have been watching it for a while. JB Welly, you know what? That was another option too when I was doing some research on this. To be fair, I do have 17,000 subscribers. So a lot of times what it said is it will push it to the algorithm to like more people that either haven't seen my channel or haven't been getting me in their algorithm. Or sometimes like people who are not subscribed like yourself, and then now you're subscribed. So yeah, this is great. I love it. I love having you. So thank you for being here. I'm waiting on the decision from the judge to fully make up my mind. The biggest thing that disturbs me is the fact that Laura, with the support of at least 99% of people online, allegedly lied to the judge in the OOP hearing. She said that only Clayton and her had those two photos, the picture of her showing her stomach in a bra and the sonogram picture. I knew that not to be true because I had them at the time, as well as everyone supporting her online. They were published on Reddit in her Dropbox, which she gave us all access to. She didn't need to lie. She either had enough for the order or she didn't. In granting the order, the judge said he was doing so because Clayton leaked those photos. I can't get my head around that, David. Maybe you could help. Have a great weekend. Oy. I think the lawyer is cut from the same cloth. Yeah, our community is the best. Thank you, Gen X lady. I appreciate you. Yeah, if you guys haven't already, hit the thumbs up. We would need the slowest mode possible. Yeah, I don't know. I don't know. The only thing I can assume is that it's being broadcast on another platform. That was one of the other things that it said, which is also why it's telling me where the or not telling me, but that new people are doing the super chats. So I have no idea. I don't know why this is happening to my channel. I don't know. I think that the biggest thing that I can think of is that it's embed on another website, because that's what it told me according to my analytics and the website where it said it was going to. Just checking to see if you said anything about Planned Parenthood denying the ultrasound came from them. You still haven't. Okay. LOL, did your crazy ass lying client reject your newest blog post? I am shocked. What? What is your opinion on your case for defamation at this juncture? Do you still believe that Laura will win $120 million and own all the houses and land of myriad podcasters? DG is actually a Muppet. I share you to Facebook. You know what, Charlene? That makes a ton of sense. So, well, the algorithm is working down under because you beat out rugby to get Kiwi watches. Hell yeah. So not YouTube with 8 likes. No, it's like, yeah. Oh, now we're at 1.1K. Okay, guys. Okay. All right. So there's 6,000 kids watching this video. If you are under 18, you don't want to be here. Please, please go tell your parents. Thank you, Miss Me. But yes, I put it on several of my groups.
Tithing to the high priestess of our Lord and Savior. 'Cause Gingras has never answered a single question and Bacon always does.
We know the formula, boobs and cursing. I have to tell you, I guess with almost 8,000 viewers, and like I don't know where they're coming from, I don't know. There's like a part of me that just doesn't want to believe it's real. Like there's a part of me that's like, there's no way. There's no way. But if you guys are watching and you are on Facebook or you're on anywhere but YouTube, I stream solely to YouTube. So it would help if you guys came over and you subscribed. I go live almost every day. I'm going to go live and do long form more. I have memberships, but I'm going to do more when my kids go back to school on August 19th. That will all start. But yeah, it's a weird it's a weird thing. It doesn't make any sense to me that like this is real. Did we see this before in a live that it was a YouTube glitch? Yeah, but why would it happen? It's happened like 4 days in a row now. So I don't know. I don't know. Anyways, thank you all for watching. I really appreciate it. Hi, David. Remember when your client lied under oath about having an ultrasound at Planned Parenthood, or is your brain too fried from your crippling alcohol addiction? Yikes. When the arguments drop to this level of mudslinging, it suggests the other side has nothing better to say.
Came for the terabitties, stayed for the smile.
Thank you, Alex. I hope it's real too. Yay, we are a sacrifice. Came for the terabitties, stayed for the smile. Oh, and then we could call them when it's a smaller day, we can call them gigabitties. They could be gigabitties. Or what else do they have? Do they have like what else comes in bytes? Terabitties. But anyways, everyone is welcome. Just don't forget the original wildlife when you get too big. Never. 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 Also, I love that he's like this level of mudslinging. It suggests the other side has nothing better to say. And he did nothing but mudsling on Twitter. Megabitties, gigabitties, terabitties. Echoes from the Tabernacle talked about your terabitties last night. So I have an announcement. I've been waiting to see Echoes in the chat, but I have an announcement that Echoes and I will be going live this Saturday at about 2 o'clock Central Time. So I will be on in the weekend. Why are such a high neckline? Because sometimes I just go in my closet and just go like that. So I will be going live with Echoes. Maybe we'll have a drink or two together. It'll be a party. And yeah, it'll be fun. Yeah, Terabitty's paying off. Let's go. The collab we've been waiting for. He's also my number one on my number one hit list. Number one. Echoes right there. Who else do I have? I got all sorts of people. So Tony Robbins and Terabitties, let's go. If you did, you would focus on that. Thank you for the lift. Okay. When a question has been avoided this early for this length of time, it suggests that it doesn't have an answer. If it did, you would just say it. Thank you for further proving your client is a liar. Not on the hit list. Whew. She did. She had the best time. I don't know if she got motorboated, but she did have the best time. The longer you avoid answering where the ultrasound came from, all right, just whatever. Everybody wants to know about the ultrasound. Okay, so we're out of that. So what do we have? Exhibit G. Oh, good. G for Gingras. And moving up, there's Peta, Exa, Zeta, and Yada. What? Biddies? Kilobitties? Megabitties? Gigabitties? Terabitties? Petabitties? Exabitties? Is that what you're telling me? Oh my God. After hours. Hi. How are you? Terabitties. GB petabitties. Oh my God. This is too many biddies. Too many biddies. Too many biddies. Too many. My sister, we got all the biddies. We got all the biddies. These large sizes are an amount of DRAM or DRAM. No one is going to be able to afford. Love it. Oh my God. All right, so this is David Gingras on Twitter. This is going to require a full blog post to explain. Great. Great. No such thing as too many biddies. Okay, and... But certain bloggers are already publishing more lies about Laura, so I'll just share this without full context. I'll explain later why, in my honest opinion, this guarantees a win for Laura. When was this dated? Does it say the date? Oof, May 2nd of 2024. Days out. In the matter of Laura Owens versus Michael Maricini, court reports videography. Okay. What is that? Exhibit H. Oh my God, why is this so big? The case for you. Can you explain? Oh, sorry, I'm confused when I said guaranteed win. I wasn't talking about the paternity case. I was talking about Laura's defamation case against people who publish lies about her. This stuff is admissible in that case, and this stuff is admissible in that case and will guarantee Laura wins, in my honest opinion. So 2.4K, that's wild. That's wild. David, my dude, what are we doing? Looks like my 120 million is back on. If there's even a remake of Gaslight, I hope you audition for the lead. This isn't going to age well. Exactly 1 month from the trial. David, I'm not sure if it's because of where I live, but I can never open your attachments. Thanks again. What, in your opinion, is a win for Laura? Well, definitely not 14 felony counts. Y'all remember that Wayne brother movie where the guy dresses like an infant? Oh, yeah, Marlon Wayans. When he's a baby, he's like an angry baby who's undercover. Isn't he a police officer? Good Wife judge who made all the lawyers say, in my opinion. Oh, I didn't watch The Good Wife. Bro. I love that. Brah. Rah. Here's the thing. They keep coming with receipts, proof, timeline, and screenshots. You keep posting vague things and claiming they are bombshells that guarantee a win. Put up or shut up. The whole transcript is there. Read it. What's the TDLR, please? TDLR. Laura Owens is mentally and emotionally abusive to Mike. The flight to Iceland with the napkin incident was Laura constantly asking Mike to forgive her for lying about being pregnant and getting an abortion. She dated Greg before Mike. She had a seizure when Greg told him she'd had them since a car accident, yet later claimed she developed seizures due to Mike abusing her. Kind of sounds like a lie. How do you have more viewers right now than Fox News? Because I have breasts and a brain. Hi, Omar. You guys, should I start live streaming to Facebook? I love the Wayans brothers. I love their song. So we're I don't want to say it. We're happy and we're singing and we're brothers. Do 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 do. Give me a high five. White Chicks, he's a cop. Oh, I love White Chicks so much. I saw that 3 times in the theaters and I cried of laughter every time. Just because someone says something, someone which may eventually turn out to be untrue does not make it defamatory. Fox lies. 7.8. I know. I don't know what's happening. No, not to Facebook. Okay. It's funny because it's true. White Chicks, it's one of the greatest. I love it so much. Oh, here's another one. Omar. Oh, Omar. This has become an Omar reading channel. Just so you know. Buying viewers for stream. This is not how I'm spending my money. Trust me. Omar's in the chat, everyone. This is how we read your motions. Hey! You know what I need? I need a button that just like turns my lights down. How am I always late? Oh my God. I would hate to hear me before I'm doing something serious. My new pre-court hearing ritual is turning on Bacon Bears. Only because our streams are now dedicated to hyping you up. I love that. He's like, I'm going to go in there and everybody's going to praise me. And then I'm going to fucking kill it in this hearing. Bacon brain beebs. Defamation also has to have proof that the person knew beforehand and the information was wrong. Like when Fox News lost to Dominion and had to pay $750 million. I want $750 million. Man. MSM. What's MSM? They should stream my channel? Okay. One theme in Owens versus Eckerd is Laura lied about being pregnant with other men. Laura says that's 100% false, and several bloggers claim she's lying because everything she says is true. Oh, mainstream media. You admitted she altered sonograms. Well, she's saying it's not true, so it must not be true, I guess. I'm about to provide some receipts you haven't seen, which may change your mind about who to believe. Coming later today. I think one of them was a made-up story, and I think one might have been legitimate. Which one do you think was legitimate the first time? And why do you think she was pregnant the second time? Oh. Altering isn't lying. Duh. Right, and she never sued for she's never sued for defamation. Curious. Yes. Okay, then we have here Exhibit K. David Gingras, and by the way, Mike Maricini is one of the alleged ex-boyfriends who certain bloggers have cited as proof. Sorry. Sorry, headphone users. Laura faked pregnancies in the past, but here is the under oath saying he did believe she was pregnant. And by the way, she was never pregnant twice with him. Justice for Laura. Are you the one who made the website? Is it you? It's only a minor perjury. This doesn't make her look any better. I don't think you're doing her any favors here, which is fine by me. Justice for Laura's victims. This is literally her ex testifying under oath. He believed she was pregnant. Explain to me how that's not good for Laura. I'm sorry if the truth doesn't fit your narrative, but it's still the truth. He's also saying that she may have been pregnant. He believes she was pregnant the first time, but not the second time, which would still mean that she lied to Michael Maricini about being pregnant. Hello? Can you can you be defamed if you publicly have a bad reputation? Like, can you be defamed if you're a terrible human being? What do I know? I love that. Nothing wrong with a spectacular boob. But all of bacon is the fillet or prime rib. Boobs are merely the sauce. The sauce! Ugh. Anyways. He also thought she had an ovary removed due to her arts and crafts just because he believed one of her lies doesn't help your case. He then said he later thought about it and nothing. Exhibit L. Exhibit L. Petitioner testified she altered an ultrasound image falsely claiming they came from Southwest Medical Imaging. She, quote, miscarried the 2 hand-sized fetuses sometimes in September or October. So, there's that. Believe it or not, George isn't at home. Someone asked me for a list of lawyers I've personally sent to jail. Here's my response. Who asked that? Who? Some comments about this week's ruling in Owens versus Eckert. Also, FYI, I previously had pre-publication screening on for blog comments due to spam. I removed that and allowed comments without any moderation. This worked. Okay. But older comments were mostly low value. So I'm not trying a 3-week time limit. Comments close after 3 weeks. Okay. What was her punishment for altering the lab reports, if any? I believe that is one of the charges in the case, and I believe that is identity theft. That's going under her. It's going against her for identity theft. So that would be punishment, I suppose. They could argue that their reputation was so bad you couldn't reduce it further. I mean, that's my argument. How do I make it worse? Oh, asked because he said he put lawyers in jail. Hi, April. Sorry, initial link somehow didn't include the PDF extension. This link will work. Many people don't know this, but to preserve or present objections at trial, a lawyer is always allowed to interrupt a witness, verbally or with a gesture. It's called quieting the witness. Oh, boy. Oh, boy. You're just that awesome. Thank you, Josie. Oh, it was Megan Fox. Okay. If you're a known liar, calling you a liar about something is not defamatory. No, I don't think so. Continually counting chickens. Hello. So this is when he's talking about when he's doing this. in court. And he's like, stop talking. You're making it worse. This practice is not just allowed and proper, it is required to preserve objections. Actually, when I asked online, every lawyer said it was completely unethical. Objections to evidence. Okay, so he just goes in here. If the witness begins to answer the question after the objection and before the court has ruled, counsel should gesture to the witness to stop and should immediately interrupt the witness by stating respectfully but loudly that an objection has been made. But I believe when she was testifying, there was no objection. He was just like, shut the hell up. Stop talking. Exhibit N. FYI, I am aware of the new evidence. I will be addressing it in due course. While that's happening, here's an odd flashback to Lo and doing a podcast together shared with permission. Whose permission? Whose permission? I doubt Mike's. Right, but DG wasn't making an objection when he was doing it. Right. And that's the problem. Greg. Greg. I would love to know. Tell him, you know what? I should message him and be like, "Hey, I'd really like a lawyer to come on my show. Would you like to do? Would you?" Maybe I'll message Legal Eagle and be like, "Hey, you want to collab?" This one. Oh boy. Exhibit O. All the best, Michael Maricini. When you've gone through everything that Mike has been through with your client, then perhaps you'll be less smug. Those are words, not details. Give me the details. Give me the souls. I need the souls. They gave you the details. They gave you the proof, and you did not listen to them. Would you like TR and B-hole? Otherwise, not helpful. She flew the kid to Iceland and Dubai. It doesn't seem like he suffered that. It doesn't seem like he suffered that much. As a lawyer, you're like, it doesn't seem like he suffered that much of a victim. Somebody claiming, okay. Exhibit P. So glad it was so easy for you. Are you being deliberately obtuse about Mike's story, or do you lack empathy? Mike dated Laura for 2 years almost. The pregnancy part of this was like minimal, if anything. So I am with my husband for, how many years have I been with my husband? 14 years this year. I'm with my husband for 14 years, okay? He's 6'2". He cocks back and hits me in the face with full force once. Once out of the 14 years we've been together. That's minimal. Also, she continues for the next 10 years to drag this out. Well, I guess he doesn't know that at that time. Got it. Cool. Cool. He said more than once that believed she was pregnant, as if that's proof Lo didn't lie. It's only proof that believed her in the beginning. Great point. Great point. Just when your disdain for Gingras has subsided. Oh. That is what I don't understand. Even if she wasn't pregnant, this has basically zero impact on any part of their lives. Makes no sense to me at all. Obviously, you didn't go through the texts on text, on text, on text, on text. This is another great point. He's minimizing her pregnancy. Does she appreciate that? Doesn't seem cool. She wrote the media, claimed rape, got his speaking gigs pulled, tried to have his real estate license revoked, and tried to have girls he didn't know served papers. So that's about Clayton. Exhibit Q. Isn't he the one who can't get jobs due to her suspicious allegations of abuse? That Laura Owens wants to have a friendly chat, although she is afraid to be in the same courtroom. The one who was dragged into this against his will and had his picture posted by you on the internet. Great point. Hit you? What the fuck? No. I'm saying. He said that they dated for 2 years and that the pregnancy thing was minimal. He's using time to the incident. I'm saying I've been with my husband for 14 years and he's 6'2". If he cocked back as hard as he could and he's only hit me once through the 14 years we've been together, because we've been together for 14 years and he's only done it once, does that make the trauma that I've endured minimal? Like, that's what I'm trying to say. Right. She used it as emotional blackmail for months. I was not personally present for any of these events between Mike and Laura, and neither were you. As such, my view is I have no idea what happened between them. The fact that you claim to have that knowledge is really troubling because you weren't there. So how do you know who is right? Exhibit R. This is about how she wants to talk about, or he'll be arrested or she'll talk to him. God, I am so happy to be through with this. Thank the Lord and Daviour. Wait, your husband? No, guys, no. It was a hypothetical. Okay. My husband has never touched me. It was a hypothetical example. Okay. David Gingras was saying that Laura used the pregnancy once in the span of their 2 years dating. And I was like, you can't say that he didn't endure trauma and he said, how bad could it be? It was minimal compared to the 2 years that they had been together. And I said, I've been with my husband for 14 years. Let's say, he's 6'2", so he's much bigger than me. Let's say he hit me once. Is that then considered minimal because we've been together for 14 years? Like, and I was just using a hypothetical because time does not negate trauma that somebody's been through. That's all. Sorry. Justice for Mr. Bears, okay? Justice for Mr. Bears in this moment. Oh, God. It was phrased a little odd, all right? Sometimes I can't words. I'm saying that you can't say that your trauma is minimal because of the time that you spent with somebody. Okay. Are we all back? Together? We're all back. Sometimes the brain and the mouth don't connect. Okay? There was TR, but there was no beehole. Good Lord, I'm sorry. I'll try to use better hypotheticals next time. Justice for Bacon Bear's words. Good Lord. I'm way behind in the live, but wanted to jump in the current chat. Hi, LSB. All right, here we go. So this is opposition to petitioner Laura Owens' motion to proceed by declaration and waive live testimony because God forbid she bring this all to court and see it through because she needs to just not have live testimony. Petitioner Laura Owens has a documented history of fabricating allegations of pregnancy, domestic violence, sexual assault, lying under oath, and presenting false evidence to the court, Exhibit A. She is currently facing 7 felony charges related to pregnancy, fraud, and perjury, including allegedly injecting herself with HCG so that she would test positive on pregnancy tests. Plus, I have a taser. Stop it. Those of us who know you knew better. I was like, wait, stop. No. I was trying to make a point. Okay, fine. I won't do that anymore. Her latest filing in California seeking a permanent domestic violence restraining order against respondent Michael Maricini is the latest in a series of escalating behaviors abusing court process as a means of silencing victims to prevent them from combating her fictitious victim narrative. Who wrote this? Omar Serrato. I should have known better. So eloquent. He didn't. He wouldn't. It won't happen. Mr. Bears is much more likely to be assaulted by me. We need Omar music. Without severe consequences, right. Right. I would jump off a table and blow out my knee like Conor McGregor trying to scissor kick him in the face if he hit me. Owens and Maricini met in March of 2016. We know that. During the relationship, Owens crafted a series of escalating narratives to emotionally manipulate Michael Maricini. This included fabricating pregnancies, miscarriages, abortions, and fraudulently creating documents to support an ovarian cancer diagnosis. Owens used these traumatic fictions to coerce Maricini into a dating relationship. For example, she used fake forged letter from a cancer specialist to encourage Maricini to be more supportive of her Exhibit C. Hey, whom is spanking whom? Some of us have been saying that. Oh, God. Frying pan. Question, has it already been brought up about Gingras on X? Is the one who spilled the beans that no one ever told Lo she was pregnant with boy and girl twins, that Lo just felt it? I don't think so. I don't think we know that yet. In the history, I don't think we know that yet. On January, Yana's right up time. Lost his tie to one. Oh no! Justice for his tie. We got to get him a tie. A new tie. I should get him a tie with Laura Owens' faces all over it. Come on now. Come on now. 2018, Maricini timely filed his DV response and denied all allegations made by Owens. Noted her history of manipulative conduct, including her fabricated pregnancies and conflicting medical claims. Owens and Maricini both submitted supplemental declarations and third-party witness statements. A hearing originally scheduled for January 26th of 2018 was continued for further evidence, depositions, and declarations. So there's that, friends. Ultimately, on or about July 10th of 2018, exhausted by the false narratives, Maricini entered into a stipulated agreement resulting in the issuance of a 2-year CLETS. Without any admissions of wrongdoing by Maricini, that order was set to expire on July 10th of 2020. Notably, there was never any finding that Maricini had ever committed a domestic act of violence. Let's see. She claimed she had an epiphany of how she was being terribly abused by Mike and then tried to distance herself after that, and he wouldn't let her, but her 1 million texts proved the opposite. Exactly. Exactly. A tie with Tony Robbins' face and bees flying. A tie of Tony Robbins covered in bees. Oh, God. Omar, your Christmas gift is about to be ridiculous. Ridiculous. Like a booger, I stick to this. Oh, man, we have brought up that Gingras called himself the Johnner McGregor of litigation. Was a better comparison than he might have thought. Yep. On the date the order was set to expire, Owens filed a request to renew, alleging fear and allegations of various violations by Maricini, which he affirmatively denies. A hearing was held on September 11th. Despite Maricini's objections, the court granted a 5-year renewal, which extended it to July 10th of 2025. Owens used this DVRO as a means of advancing fabricated narrative that she was a domestic violence survivor. She made up multiple statements, TED Talk, chicken soup, bomb, bomb, bomb. This is what I think of all of that. Owens continued her use of falsifying pregnancies with 2 new victims. She sued an Arizona man for abortion coercion. After she claimed he impregnated her with twins and then later claimed to have them aborted at his direction. When this man refused to continue dating her, she obtained a protective order against him, which she renewed from 23 to 24. Owens was the subject of a public legal controversy involving another false twin pregnancy allegation against former Bachelor Clayton Echard.
Don't ever leave us. Bacon emoji, teddy bear emoji, white heart emoji.
Thank you for that heart, but where am I going? Where am I? Bitch, I ain't going nowhere. You ain't, committed. I'm committed for life now. Don't you worry, Elsby. Don't you worry. I'm not going nowhere. So another false twin pregnancy allegation against a former bachelor. When Mr. Echard refused to continue to date her, she got an order of protection against him as well. Okay, great. The litigation with Mr. Echard went on to June 10th, at which time Owen's prior victims, including Maricini, were lawfully subpoenaed. Okay, we know that. Non-paternity. The court found Owens had acted unreasonably in the litigation, initiated litigation without basis or merit, provided false testimony, and that Owens' petition was fraudulent and made to incite communication, a relationship, or both with Echard. Moreover, the court found that Owens had a pattern of similar, if not identical, behavior. Great. And then she was told to give him some monies. I just like to draw on my screen for no reason. So... Thanks, friends. Let's go over here. Okay, great. I was focused on listening when I parked my truck. Now I don't know where I'm in the park. I hate that. Did she ever receive any benefits under the domestic violence funds for that state? If so, the state can file for her on fraud as well. Look into that. Oh, that's a great question. I don't know. On May 6th, Owens was indicted. She has 7 felony charges for the first one and then 7 felony charges for the next one. Owens filed a motion to proceed by declaration and waive live testimony to silence Maricini in furtherance of crimes she is currently being prosecuted for in Maricopa County. This newest abuse of process constitutes witness intimidation in violation of PC 136.1. Owens' bid to avoid live testimony is an affront to fundamental due process and a disgraceful ploy to shield her chronic falsehoods from cross-examination. Owens' current felony defendant of 7 felony counts for conduct that involves the underlying facts of this case. The substantive DVRO matter involving a restraining order where there has never been a finding of domestic violence regarding material facts hotly in dispute, where Owens' credibility lies at the very heart of this case, and she has none. None. Petitioner's motion attempts to evade cross-examination and continue her criminal pattern of deceit. Owens' documented history of perjury, forged evidence, and validates her pleadings. Her claims must be tested under cross-examination. The court should deny petitioner's motion, requiring her hearing on renewal to proceed as an evidentiary hearing with live testimony. In addition, respondent Michael Maricini requests that the court impose appropriate sanctions for Owens' abuse of process and refer this matter to the district attorney for investigation of potential crime conduct, including witness intimidation and offering false evidence. Again being the key phrase. She didn't get help from a DV program getting the DVRO. Oh, she did get help for getting the DVRO against him. Interesting. Over $1 billion funds. That's interesting. Why does this sound like it? Because it is a real filing. Because Omar slaps. Live testimony is required by law. Under California law, live witness testimony is the rule, not the exception. All right. California court rule, by enumerating factors a court shall consider before denying live testimony. The factors include whether material facts are in controversy and whether live testimony is necessary for the court to assess the credibility of parties or other witnesses. Each of those factors decisively favor live testimony here. This is a contested DVRO renewal involving diametrically opposed accounts of past events where virtually all material facts are in dispute. More importantly, credibility is paramount. Yeah. Owens' case rests on her claims of fear and past abuse. This renewal hinges on whose narrative to believe. The California Evidence Code explicitly recognizes that determining a witness's credibility, the fact finder may consider any matter that has a tendency in reason to prove or disprove the truthfulness of their testimony, including the witness's demeanor, character for honesty, and prior inconsistent statements. Yes. Yes. When going, you can't. Preach, Omar. Right. Preach. Your eyebrows are amazing. I must know how you accomplish such perfection. Do you use a gel? Do you share? So, I use, all right, I'm going to do this. I always say I'm going to do this and then I don't. I'll film one this week for my members only because everybody asks about my makeup and I will show you how I do it. I use a $4 tub, and it's a big tub of edge wax, actually. I use edge wax, and then I have a bunch of little spoolies, but I always brush them back this way to make sure the gel's in there, and then I brush them back this way, and then I brush them up, and then I put my fingers over them, and then I fill in the sparse areas. So that's how I do it. But I am going to do a get ready with me because everybody asks me about how I do my makeup, so I will do that. And then that'll be in my members only, and I will let you know. But I have always found for myself, I love edge wax. And also, it's so much cheaper than brow gel, and it works amazingly. What is it? Stop it. Stop it. Those credibility factors cannot be meaningfully evaluated on the cold paper record. A declarant's written words reveal nothing of her tone, hesitation, or eye contact, and they prevent the opposing party from probing inconsistencies in real time. Yes. Yes. So, at the Dollar Tree. I've gotten them at the Dollar Tree before too. This one was from Target and I love it. It's got like a little pink top. I love it so much. Who's new here? Hi from New Zealand. Hello. Welcome. Look at us and our international friends. I feel so important. To assess the credibility of Owens, whose honestly is very much in question, the court must observe her live under oath and under cross-examination. California courts have consistently emphasized the importance of live testimony in contested matters, particularly cases involving restraining orders or other significant issues where credibility and due process are at stake. The courts have condemned decisions based solely on written declarations without providing parties the opportunity to present live testimony, cross-examine witnesses, or otherwise fully participate in the proceedings. So, the appellate court in Marriage of DS and AS emphasized that both family code governing DVRO issuance and due process principles require a proper evidentiary hearing with witness testimony. Oh, also, wherever this live stream is being streamed on another platform that isn't YouTube, I know that you guys can see what's going on in real time, but I don't know if you guys can chat. If you guys want to come and chat with us in real time, you have to move over to YouTube so that you can get in the chat. We would love to hear your opinions. So do that. And my girl from Canada, yay! I have no patience for makeup though. I just started getting laser treatments and go out with nothing but sunscreen on. It's an expensive alternative. That's okay. Taking care of yourself. Here, Owens wants the court not only to consider issuing a permanent DVRO renewal against respondent, but she desires criminal prosecution. Yeah, we're all about hearing from the viewers. We want to hear it's called my opinion. That's my opinion, but also it's like also all of our opinion. So, but she desires criminal prosecution without ever hearing directly from either party in court. Granting such a request would violate the letter and spirit of of 2017 and Rule 5.113, and would almost certainly constitute reversible error as a grave miscarriage of justice. With your YouTube channel for people not watching on YouTube. Oh, what does that do? Does a QR code bring them here? Red Rover, send viewer right over to live chat. Does that work? Maybe I should put like a little QR code in the bottom so they can come straight to the YouTube channel. Huh. That would be fun. How do I make one of those? Respondent intends to testify and present evidence after being properly noticed and served to refute Owens' claims. He has a constitutional right to cross-examine Owens on the stand. Yes, he does. Owens cannot unilaterally waive the presentation of live testimony when the other side demands it. In the absence of any stipulation, the court must take live testimony unless Owens shows specific good cause to refuse it. As explained below, there is a compelling cause to require Owens to appear and testify. Oh, El Jacad, thank you. Right. You have the right to face your accuser. Yeah, if it was on screen. Mr. Pike, that's such a great idea. Thank you. Oh, text packet? You too? Yeah, no. Yeah, if you guys, so, well, if I watermark, then it'll be over the all over the screen. Do I just put my name like on YouTube at Bacon Bears? Justice for Pineapples. It'd link them to scan it for sure. Okay, that's a good idea. All right, let's make a QR code. And then also, I just need to put like a little thing on the screen with my name. Watermark and QR code. All right. Got it. Stop it, Mr. Pike. Now say something nice about yourself. Oh my God, you guys. I'm late to the stream, but Queen Jen knows about the contradiction in the recent. Because oh. Well, there's that. There's that. Petitioner seeks to evade cross-examination as her claims cannot withstand scrutiny. Owens knows her narrative will collapse under cross-examination. Boom. Owens' goal is not convenience or efficiency, it is concealment. First, petitioner's professed reasons for avoiding live testimony to the extent she articulates in her motion do not hold water. Owens claims she feels traumatized. Thank you, fake Laura Owens. Thank you. Or fearful of being in the same room as respondent. After obtaining the DVRO in 2018, Owens actively sought out contact with Maricini, messaging him repeatedly, approaching his family, even traveling across the country to confront his employer with her allegations. What? Traveling? When did this happen? 30 seconds from 30 seconds from later. Hi, everyone. High chances are low. How are you? When did she travel? In September of 2024, while on a trip to New York, Owens made an impromptu stop at Maricini's HR department to alert his employer that he had a DVRO issued against him.
Watermark? Oh yeah, I'm gonna watermark you.
Laura, that's what got you into this mess in the first place. Hi, Lushburn. I'm gonna go into this interaction looking like fucking Paddington Bear. The hat, the coat, the galoshes. You ain't gonna get nothing on me. Splash. Splash. Make a splash like Pippin. She gave a TEDx talk in January describing herself as a domestic violence survivor and recounting her accusations against Maricini. She authored a Chicken Soup for the Soul. So the things that I want to know about this, though, is she protected because she didn't use his name? That's what I want to know. I really can't wait for Michael's appeal. so we can get more. That'll be coming out at the end of this month. So we got a couple more weeks. Was Hoboken the same time? No, I believe Hoboken was with Greg, not with Mike. In none of these very public forums did Owens exhibit the slightest hesitation about reliving her claims. Yet now when it comes to actually substantiate her accusations under oath, Owens suddenly shrinks back and pleads to do it on paper. Oh, Omar. Can we do a brainstorm of what jobs Lowe should try? Obviously, you have service industry, maybe gym instructor giving horse lessons. Yeah, I don't know. Her newfound reluctance is not about emotional difficulty, it's about avoiding the exposure of lies. Second, petitioner's procedural conduct shows a desire to ambush and silence respondent rather than a bona fide need for accommodation. She hadn't even served Maricini with the renewal request or this motion, presumably hoping he might not appear at the August 1st hearing, allowing her narrative to go unchallenged. In a declaration, she can say whatever she wants, blatant falsehoods, without the risk of immediate impeachment. Yes. But somewhere. It's in your DMs if you haven't found it yet. Yeah, let's put it up. That's awesome. Thank you. All right. Give me 1 second. Let's see if we can let me see if I can do this real quick. And that way, let's see. If people want to create QR. Thank you for doing this. Whoops. This one. Oh, yeah, boy. Look at us. We are professionals. Believe it or not, George isn't at home. Please leave a message at the beep. All right, we'll just do like this. Here, and then I'll go like this, and then I'll copy, and I'll pasta here. Oops. All right. We'll do this. And then we'll copy, paste. Oops. Hello? Copy. Why? Why can't I copy it? All right, let's just try this. Browser. Add existing. QR. Okay. Boom. There it is. Look at you guys. All right. So if you guys are on another platform and you want to come watch us on YouTube and you want to be in the chat and you want to raise up, we raise you up. Why did that come up? I don't know. But if you guys want to come be in the chat with us, hit that QR code and it'll send you right over here. Yay! Thanks, guys. You guys are the best. For Colorado, please. We lost another firefighter. Oh, no. Ugh. Testing lie detector machines? Ugh. I'm convicting her immediately. It's over. It's over. It's done. You guys, I've been YouTube featured. What is going on? What is happening? Okay. What? No, I just it's not a bad thing. It's just I don't Thank you. No thanks.
You deserve it.
It just like, I don't know. It's weird because it's like all the people that I watch are like featured. It's the power of the TR, beehole, boobs, and bacons and utter nonsense shit. Honestly, I don't understand. Not we knew you when. You still know me. I'm still here. You deserve it to be featured. Do it, do it. I know, it's just weird. I have imposter syndrome. I'm like, why are you doing this? Oh my God. I don't know what's happening. Okay. I don't know. I'm like, so weird. Anyways. Nah, you've changed. Shut up. Anyways. Good Lord. Don't forget us peons. Get out of here. I would never, except for right now when I forget all the little people I stepped on to get here. Oh, God. The California Court of Appeal reaffirmed that denying a party the right to testify or offer evidence is reversible per se. The court emphasized that family law judges must ensure a full and fair opportunity for parties to present all competent, relevant, and material evidence. Litigants have a fundamental right to testify and call witnesses, subject to reasonable limitations such as excluding cumulative or unduly prejudicial evidence. Will you continue? Ew. Just don't go J-Lo on us, where I have somebody else come in and do it. Will you remember Charlie and Charger? Yes. Yes. Whip out them biddies and go to trial. I will at the end. I will. I promise. It's just so, I don't know. We're doing it, guys. We're doing it. Hooray! Anyways. Owen's bid to avoid testifying is an attempted end run around the truth-finding process established by basic due process. The last time Owen's claims were tested under cross-examination, she perjured. Oh, I love this, Omar. I love this so much. I love that he underlined this. She perjured herself to such a degree that she is currently facing 33 years in prison in Arizona. Say it to me slower, Daddy. You were YouTube famous for TRP. Oh my God. Don't forget your co-stars, honey. I'm nothing without you. Just remember that. I'm nothing without you, chat. She fails to represent in any of her filings that there have been a judicial finding that she lied under oath and a looming criminal prosecution for perjury. A litigant who has demonstrated propensity to lie cannot be given a pass to litigate via unsworn paper or unchecked declarations. Chat is bae. Chat is bae. Proud of you, girl. Recognition for hard work is always a reason to celebrate. I know. Thou must not forget us, thy peasants, on thy rise to the high of the socials. In famous last words from Gingras, no one gets charged for perjury. I also said that. It was so funny because I said that in one of my videos, like one of my very first videos about her. And I was like, you know who gets charged for perjury? Nobody. Ida B.
Yeah, you.
That sounded so sarcastic. Yay, you. Thank you, Ida. Petitioner's motion and renewal for a request are an abuse of process aimed at harassing and intimidating a witness. Owens is now a criminal defendant in Arizona. Michael Maricini is a material witness in that pending case. The state's disclosure explicitly lists Maricini as a witness in State versus Owens. Owen's aggressive pursuit of a renewed restraining order and her insistence on doing so via declaration appears calculated to harass and intimidate Maricini in violation of Penal Code 136. It's just a little perjury. It was minor. Thanks be to Dave for my success. I gotta wait for this song to be over. Looking forward to TR bringing you on stage. I'm going to shoot a confetti cannon out of my beehole. It sounded a bit more excited in my head. It was so funny. Yay, you. To be fair, if you drop all the perjury charges, her remaining charges would still be quite serious. This isn't the first time she's used this tactic. She's already tried to have Maricini arrested for violating the instant DVRO because he complied with a lawful subpoena where he was listed as a witness. She claimed his appearance by lawful subpoena was the basis for her renewal. She failed to represent to the court Mike was complying with a lawful subpoena. Owens is dragging Maricini back to court on baseless allegations and to obtain an order that would paint him as an abuser forever. Owens sends a clear message: if you cooperate with law enforcement against me, I will continue to make your life hell in court. I mean, who came in late that didn't get a bunch of stuff wrong at first? It was impressive. Thank you. You gonna take all these new peeps to church? I mean, I can write a sermon for Wednesday if you'd like one. The world can only handle so much awesome at once. Aw, Seamus, thank you. That's really sweet. This raises a specter of witness intimidation. The timing is suspect. Owens let the prior 5-year DVRO renewal run its course until just a few weeks after she was indicted and officially learned that Maricini could testify about her past lies. Wow. What a great Bruce, yuck. Ew. Poop flakes. I didn't even realize the timing on that. She let her prior 5-year DVRO renewal run its course until just a few weeks after she was indicted and officially learned that Maricini could testify against her. Interesting. Need a sermon on Wednesday. Okay. I will write one. Sermon. Oh, boy. Then suddenly she moved to extend the DVRO, which was about to expire, and concurrently sought to eliminate live testimony at the hearing. This inference is unmistakable. Owens wants to discredit Maricini and undermine his standing as a witness against her. And he would have the most evidence against her, I think. So is that our official day? Yeah, why not? Wait. Why is this judge not doing referrals to the DA's office for prosecution? They did. She's currently facing 14 felony counts. That's where we're at. My headphones. Oh, I'm sorry. I'm sorry, Tiffany. I'm so sorry. Sorry. I'll try to remember to turn my mic down when that happens. So if she takes a plea, then she has to allocute. Am I correct? The fact that they offered the plea makes me want to throw up, but, well, that's a good question. I don't know. I don't know if she does. And that's going to make me very upset if she doesn't have to, admit the guilt. So, there's that. She emptied the mom's. No. Ew. Outside time? Why? So you can run away? What do you think this is? This is an outrageous perversion of the DVPA. The DVRO system is meant to protect victims, not be wielded as litigation weapons against someone who might testify in another proceeding. Courts have repeatedly warned against using restraining orders as tactical weapons rather than shields. Okay? Owens is currently subject to an order of release from Maricopa County in connection with 7 felony charges, including all of these things. And she is now asserting here. Standard conditions of such an OR release generally prohibit defendants from leaving the state absent explicit judicial permission, right? So you have to ask. Do it. We believe you. Binky, I love that. That makes me so happy. Considering her counsel is asking for money for experts makes me think she's headed for trial. Me too. I also agree with that. What no one is explaining is if the trick is even is that even if she takes the plea and pleads guilty, the judge doesn't have to abide by the sentence agreement or accept the plea. Also, yes. Also, yes. Wouldn't that be amazing? Remember me, though you have to, though I have to say goodbye. Remember me. Yes, everybody, if you're enjoying the stream, give it a thumbs up. Owen's physical appearance in California to participate in a contested evidentiary hearing requires prior approval from the Arizona Criminal Court. To seek that approval, she'd have to alert the criminal court that she is currently engaged in the same criminal behavior that she is facing 33 years in state prison for in Arizona. The underlying facts of this case necessarily form part of the foundation for the criminal case against her in Arizona. Interesting. Every time you sing that song, my plan to bud another leaf or flower. Do it, do it. When she walks into court, Billie Jean should be playing. Billie Jean is not my lover. The Arizona indictment is related to Owen's history of fabricating evidence and submitting false statements under oath. To participate live in these proceedings, Owens will have to convince the Arizona criminal courts to travel out of state so she can participate in proceedings to continue criminal conduct that gave rise to her felony charges. It is exceedingly unlikely that an Arizona court will authorize such travel. This continued criminal conduct should be referred to the local district attorney for criminal prosecution, as Owens' behavior continues to put individuals at risk of further victimization. This court should not implicitly endorse Owen's attempted evasion of her OR conditions by allowing her to proceed on paper alone. Thank you. Is that double jeopardy? Is what double jeopardy? Plea requires admitting guilt to the facts voluntarily to a judge. If the judge determines you're not admitting guilt, he might not accept the plea and goes to trial. But she could admit guilt and not elaborate. She could just plead guilty and like not elaborate on that though. And the contained screams with it. An angel gets its wings. I think the court is allowing the time to reach the settlement to avoid any cause for an appeal down the road. We are enjoying the screen, you put it, girl. I wonder, I know Ville Marie, it's crazy. I wonder what she's up to in Cali. Did anyone check her travel plans to the appeal there? Oh, interesting. Yeah, I guess the timing would be right? Well, no, she left. Like, when is she coming back to Arizona? Also, when you ask a court or you ask a state to be able to leave to go to another state, do you have a time limit? I mean, I would suppose she just has to be back by the 22nd of July because that's when she is the next time she needs to be in court. Oh, I think she's already back. Okay. Additionally, this court cannot ignore Owen's documented record of dishonesty, forgery, and perjury. Perjury, girl, perjury. Given this context, permitting Owens to avoid live testimony would be extraordinarily prejudicial. Her declarations, unchecked by immediate cross-examination, would shield her from confronting demonstrable contradictions and fabrications. Moreover, given her OR conditions, Owens' ability to even physically appear at a hearing in California is doubtful without judicial authorization from Arizona, authorization that no responsible court would likely grant under these circumstances. She has to outline it. However, her bond restrictions delegate. Okay, I see. Thank you. What horse shows are in Cali during the time she requested to travel? That's a good point. The dates were specified. I just don't remember them. Also, I never leave her alone with my children. Right. Owen's bid to seal the proceeding conflicts with California's strong presumption of open courts, as a court record and hearings are presumptively public under California law. California rules explicitly state that court records are presumed open unless confidentiality is required by law. This principle is rooted in the public's First Amendment right to access court records. I know that's right. I know that's right. Her requests for travel have had a start and a time end. Okay. The more you know, you learn something new every day. My guess is her babysitting was really going to ask Sarah to cover expert witness and private investigators, but she said no. Oh. A trial court may order a record sealed only if it makes express factual findings that 1, there exists an overriding interest that overcomes a right to public access, 2, the overriding interest that supports sealing of the record, 3, a substantial probability exists that the overriding interest will be prejudiced if the record is not sealed, and 4, the proposed sealing is narrowly tailored, and 5, no less restrictive means exist to achieve the overriding interest. These stringent requirements codify constitutional standards and make clear that sealing is the rare exception, not the rule. Petitioner has not come close to meeting this heavy burden. She identifies no overriding interest sufficient to overcome the fundamental presumption of open access. Her claimed basis for secrecy is not the protection of any legitimate privacy interest, but rather an effort to shield herself from public scrutiny. Too late for that. The bankruptcy stuff was due on July 10th. So that was due on last Friday. I want to ask an attorney a question. Why can't a court use another court's testimony in another courtroom, AZ area? They can. I think they can if it's admissible. If they can. I've seen them do it. But his argument, they want to be able to cross-examine her, is the argument. Avoid embarrassment from challenges to her credibility and prevent the public from observing her ongoing criminal conduct. Yes. Avoiding personal embarrassment and reputational damage. Reputational damage.
Emotional damage.
While concealing criminal conduct is not valid ground for sealing under California law, Owens has actively publicized the very allegations at issue in this case. By her own account, petitioner has openly discussed her relationship and abuse claims in public forums, including a TEDx talk, describing how a note from a stranger, oh my God, this note, if I never hear about this note again, I will be just fine. Just fine. What do I have? She has published an essay and made media appearances touting her status as a domestic violence survivor, voluntarily disclosing details of the alleged abuse. She also initiated prior litigation in 2018 based on these allegations, which was heard in open court and resulted in public court records. God knows she can't have that. What note? Exactly. Thank you. Thank you. There will be no more notes. Having freely injected her story into the public sphere, petitioner cannot now credibly claim a compelling privacy interest. Right. She was a budding TV personality, I believe she said is what she wanted to be. Right? The same narrative from public view. Owens has painted respondent as an abuser in the court of public opinion through interviews, online posts, and public talks. Yet she now seeks to close the courtroom doors and keep the actual evidence and testimony hidden from the same public. This one-sided use of secrecy would severely hamper respondent's ability to clear his name. Fundamental fairness dictates that respondent be allowed to rebut petitioner's allegations in an open forum so that the truth can emerge. The California rules recognize that transparency is crucial not only for public confidence in the courts, but also for the integrity of the fact-finding process. Petitioner's attempt to seal the record is an effort to control the narrative and avoid having her claims tested under the glare of public scrutiny. The court should emphatically reject this request. Deny petitioner motion. Oh my God, I am losing my ability to talk. Deny petitioner's motion to proceed by declaration and order. Where's my marker? Give me my marker. Order that the hearing go forward with live testimony after proper service has been effectuated. Both parties and any other permitted witnesses should be ordered to testify under oath, subject to cross-examination. And that's the thing, right? You can try to write whatever you want. You can do that. But to write it on paper, and yeah, be in the court. Like you're going to see her crumble. You're absolutely going to see her crumble. No doubt. There's no doubt about it. Oh God. All right. Hold on. Apparently my daughter just got done swimming and she says that her belly hurts. So, she was trying to seal. No, it's not that she was trying to seal anything. It's she wanted to testify by paper. She wasn't trying to testify in court. The petitioner has not met the stringent criteria in the First Amendment. Common law rights of public access would be unjustifiably infringed by the blanket secrecy she seeks. She doesn't want to come out and embarrass herself. Do you think she tried out for The Bachelor ever? They said she has an audition tape. Tossing a match and walking away. Oh my God. Bad faith. Let's see. For bad faith litigation conduct, Owen's litigation tactics include failing to serve her opponent, attempting to mislead the court, and persisting in claims known to be false, have needlessly increased the cost of this litigation and undermine the policy of cooperative resolution. For possible criminal investigation, the evidence before this court suggests that Owen's actions are not merely civilly actionable, but criminal. Good. Respondent for Michael Maricini respectfully urges the court deny petitioner's motion. Okay, so we are on page, what are we on? Page 14, sorry. So this will be Wednesday is opposition. Opposition to petition. Page 48. This is where we will pick up on Wednesday. I have to go. It is my time, friends. I actually wish she had been selected for The Bachelor because she's one person the producers wouldn't need to manipulate to get her train right. Oh my God. I can't imagine. I cannot imagine what that would even look like. So with that being said, if you guys are new here and, please sell it to me. Sell it to me. If you guys are new here and you are not subscribed, please consider doing so. I go live almost every day. We have long form videos coming back up once my kids get back in school. If you have not liked the stream already, please consider doing so. If you get the option to hype, it helps out the channel a lot. I cannot believe that we were YouTube featured today. What the hell? But we're doing it, friends. We're doing it. Also, I will be back on Wednesday. I won't be here tomorrow. But I'll be like in the Discord and I'm always like hanging out in the comments. But mostly you can, if you want access, I'm mostly like in the Discord, just like lurking around. And then what else do I have to tell you? I think that's it. With that being said, thank you guys for today's stream. I will see you Wednesday. You guys are the best. Okay. Bye-bye.